What's up, people? Welcome to the madness. Welcome to the madness. I got my boy Uncivil Law. Oh, he's here. He is going to be joining me today to go over the madness. I watched his live stream yesterday and Emily Baker's, and it was wild. Let me see. How's everybody doing in the chat? Oh, Secret Squirrel is here. Boom. Allison. Oh, all right. We got the whole crew here today. Boom. Uncivil Law trying to pass some info over to someone regarding the stream on Dover Rekill. All right. Well, he'll be here in a second. Hey, what's going on? How you doing? So you guys know we are here for the insanity, right? We are here for the insanity without a crystal ball. Toddy Westbrook. I'm going to go over it. Let's just make it happen. This is insane. So let me bring in my boy in Civil Law so he can see what's up. There he is, the man, the legend, Uncivil Law. Say hello.
How you doing?
Same old, same old. I'm just watching this, trying to make sure my manual focus is in focus. And just saying, what's up? So what's going on with you, brother? How's everything going?
Oh, things have been going reasonably well. I had a really nice positive stream last night. It didn't hurt in any way. The filing was only 17 pages long. So I didn't have the drudgery of like 150 pages, and my will to live evaporates during a short period of that. So that was really nice. Just a little quick, little amuse-bouche, little palate cleanser, a little in and out, just a little bit of fun. I think it only took an hour instead of 4. It was nice.
But hey, it's funny because I feel like I'm watching too much of this case. I watch every minute of your breakdown, then I go watch every minute of Emily's breakdown. It's just fascinating to see all the different takes on this case. But and it's funny because most of us, myself, you, and Emily, all kind of, we all come to the same conclusions, even though we have like minor differences. But on the legal stuff, we're all exactly the same. Like the hearsay issue, this issue, we all are. It's more or less identical.
Yeah, it's interesting watching our different perspectives or how we approach different problems, and even places where we sometimes disagree. Just because it's interesting seeing how different people think. And when you have like the same thing that you're analyzing, then you can really manifest those differences much more concretely because you're dealing with the same source material, and you can see how different people think given the same root issue. So it's
That's
kind
true.
of fun
Hold
that
on,
way.
let me put my chair up. My chair, I feel like it's too low, but then I feel like it's too high. There we go. Get a little space on my chair so I can sit up. I want to be on a throne today. Yeah. All right, here we go. This is live TV, people. Live TV.
And also, I decidedly was not looking at the live chat while I was doing the live stream, and I was better for it. So, notes for my mental health.
There's the
too many voices. The problem is, it's too many voices in my head. When I'm reading not literally like verbally, but it's just too many things, too many ideas I'm trying to consider at once, too many perspectives, and it's really distracting, and I think presents problems. So I love you guys in the chat, but sometimes it's a little overwhelming.
Thank you, Stuart, for the super chat. No, it does get it. But I always feel that the chat, I like interacting with the chat, but sometimes you just got to let some of these comments go because sometimes there's some stuff out there. Sorry, so
maybe that's my problem. Maybe I just don't know how to filter yet, and so I just kind of absorb it all. So it's kind of an all or nothing, which would be very in keeping with my personality. I tend to go to more extreme things before I moderate out somewhere. So yeah,
that makes
like
sense.
An all or nothing before I learn how to be in the middle.
So you know what? Before we get into this case, while people are running in, I think this is the best time to do a review on what the hell this case is about and how the hell we got where we're at today. Right before we go into this monster, I will say this was a monster response by Saltz. Saltz, to me, he killed it, but first, let me give people the background. For those people who've not seen or heard this case ever, let's just start at the basics. This is Tati Westbrook. Now, who is Tati Westbrook? She has, how many subscribers she has on here? 8.95. She had like 9 million subscribers.
That's good. That's subscribers.
So she is having...
She's kicking her ass, Nate.
Yeah, this is somebody who's kicking our ass. Now, she is suing our homegirl, Katie Joy Paulson, right?
Your homegirl, maybe.
That's true. My homegirl. She's suing Katie Joy Paulson for a couple of million, whatever they're suing it for. But let me show you what KJ looks like. So she's suing who we all know and love, especially you people in the chat. I know people are like, we don't love her. We hate her. She's suing this person, Katie Joy Paulson. Now, as you can see, Katie Joy has 139,000 subscribers.
Which is also kicking both of our asses, to be quite honest.
Which is also kicking both of her asses. So you have these two, women who are suing each other based on this YouTube beef. Now, this is a defamation suit, right? So Katie Joy Paulson. Yes. So let me just this is just the overview. Katie Joy Paulson is supposed to have had, right? She's supposed to have had defamed Toddy Westbrook and hurt her business and blah blah blah. Defamation, some defamation per se, defamation this, right? So let me get the $5 super chat from Secret Squirrel. Thank you. I won't send you any long words in the super chat today. Thank you. Or you got to spell it out phonetically so I can read it. Thank you, Secret Squirrel. So just so we're clear. Now, where are we at in this litigation? Well, just so we're clear, Toddy Westbrook has written her complaint and submitted to court and filed all her filing fees. And in that complaint, she has made a whole bunch of allegations, right? Here are all the allegations. Mm-hmm. Now, there are two things that the defendant here, Katie Joy Paulson, could have done at that point in time. And I've been saying this for the past months that I've been saying it, but I'm just going through it again. Katie Joy Paulson could have denied all allegations. I deny all this, right? Answer the complaint straight up. Say, I deny all this. You're wrong, and I can't wait to see you in court, right? She could have said that, but she did. She took option B. Option B was, you know what? Even if everything you say in this complaint is true, you can't win. It's bull, right? Yeah. That's what she essentially did. So she filed a motion to dismiss, and she gave a couple of reasons. Now, generally, you'll say, well, if everything you said was true on the defamation claim, you can't win because it's an opinion. It, wasn't published or whatever. But she didn't do that. She didn't even do that for the defamation claim. She really said, this court has no personal jurisdiction over me, right? This court can't tell me what to do in common language. This is what, F you court, you can't tell me to do nothing. You can't even hold me in a court to make me answer these claims. Even if everything she says is true. Now, I had a quiver with someone. I had a really, really, really tough quiver with someone who didn't understand this concept and said, well, Nate, of course everything she says isn't true. Of course you can't believe everything.
Yeah.
Understand this.
Yes.
Think about it this way. There are maybe the jurisdictional piece is confusing people's minds. Think about it as if it was statute of limitations. You have a certain amount of time to file an action, maybe a year. You wait 3 years. So you file your action, and the other side says, well, you know what? I don't care what the action says. You filed it too late. The statute of limitations has run out. So I'm filing a motion to dismiss. It doesn't matter what you have in the complaint. You filed it too late. The judge looks at it and says, well, you did file it too late. Dismissed. That's where we're at here. Instead of statute of limitations, we're talking about jurisdiction. So when people say this is a tie, what Toddy said here is wrong, what Toddy said here is wrong, that at this point is irrelevant. Why? Right. Because assuming everything she says is true, do you still have a claim? So you're not arguing about the facts of the underlying claim. There's really no discussion on the merits of the action. We're just talking about if everything this plaintiff is saying is true, if it can be proven, can the action go on? So Kurt, do you agree with that assessment?
Absolutely. I mean, there's a difference between it's not true and it doesn't matter if it's true. There's a whole lot of things that can be true that might not influence any particular situation. So, I mean, for example, if I said, I'm going outside today, to go to a bar, and you said to me, well, you can't do that. I said, why? Well, because New York has a shutdown. I'm like, that's great, but I'm not in New York. So even if it's true, and I don't know if it's not, I don't care either way because there's no influence on me because I'm not there. So it's like, yeah, I don't really necessarily have to take a position on whether New York has lockdowns on bars or not because I don't care. Either way, it has no influence on me. So yeah, that's basically what the motion to dismiss is supposed to be. It's like everything you say, if we assume it's true, it doesn't matter. Its truth or lack thereof is irrelevant because even if you're true, I win. Perfect. Your legal theory doesn't work. It's like saying, it would be something like saying, I should win this lawsuit because I'm wearing a green shirt. And me saying, okay, I guess you're wearing a green shirt, even if it's really red. But be like, even though it's really red, it'd be me saying, sure, you're wearing your green shirt. Who cares? It doesn't have any influence on this legal claim. So I don't know if that example's helpful, but
But listen, I'll say this also too. It also matters that sometimes now people will say, well, what happens if she says, it was a Thursday, but it was really a Saturday? Well, obviously the court, something like that's factually inaccurate like that will actually be taken into account, right? The defendant can say, well, no, that's not, that just factually is incorrect. It just is so crazy that can't be the case, right? That's things the courts take into it. They're not dumb, right? But it comes to the point where if I'm saying X happened, you're saying Y happened, then the court will say, well, you know what? The non-moving party, whatever they say, we're going to accept it as true just for this limited scope of the motion to dismiss. Let me get the super chat since at Secret Squirrel won't. Expialidocious, right? How do you know how to say this word? From
Supercalifragilisticexpialidocious.
Yes, what's it from? Mary Poppins, right?
Mary Poppins, yeah.
Yes, say it again.
Supercalifragilisticexpialidocious.
Boom. You see, Teresa, that's why I have a wingman right there. Boom. If he's in the bar, he'd be the wingman right now. He just took it from me. Thank you. Because I would have struggled with that for the next hour. Thank you, Teresa. Thanks for the super chat. Minnesota. So I'm hoping this
and something that could matter in one instance could matter in not instance. So everything is context dependent. So it depends like what context you're in. Because again, trying to make analogies that would make sense, it would be something like a sequence of events occurs in a football game. And it could be a foul in one instance and not a foul in another, because other things would be true or other rules are in play, or because of situations that might be dependent. So the exact same thing could be like irrelevant one moment, irrelevant the next moment. The rule could be applicable one moment, not applicable the next moment. So things change, and it's like, okay, well, for the purposes of our current moment, here's the current reality. We'll assume on the current reality, deal with that reality, and then we'll move on to other realities as we need to. So
yes. Now, if we also take this case in steps, step 1 is the filing, step 2 is the response, step 3 is discovery, and steps like that. We're at step 1, right? We haven't even gotten to step 2, because step 2 would be, I didn't do this crap, right? That's when the denial of the allegations. That's
the answer. It's not true.
So step 1 here is, at step 1, we're at everything she's saying is true, because again, officially, no one has denied these allegations. So I want to make very clear where we're at, why we're here, and how we're going to be reviewing these documents under this same standard, right? It's not because we believe Toddy over Katie. It's not no, it's just because the standard forces us to say, if we're going to judge this motion to dismiss, where we're at, right? I can't say Katie's denying allegations that she hasn't denied yet. That just doesn't make any sense, right? I can't say that. So I'm going to just use the legal standard here.
If she has denied allegations, then she has a massive problem, because that means she's waived jurisdiction, and this whole thing is pointless. It means we just lit $150,000 on fire. So if she has denied it, $150,000 just went up in smoke in a pointless way. So that's fun.
Yes. Yeah. Thank you for the $5 super chat, Tadded. Nate had a group of lizards attack me. That's true. I went against them. So what's up, Nate? I know. I need to now get some more or something. This is crazy, man. I tried to stop that super chat, but it didn't work out. So now we all understand where we're at in this litigation. Now, I also want to say this. Now, since we're at step 1, we're not at step 2. We haven't even gotten to step 2. There's like 12 or 15 steps. We're at step 1. We haven't even gotten to step 2. So generally, in most cases, you get something like 40, 50 docket files, right? At most.
In the entire case? Yeah.
In the entire case.
For instance, yeah.
I took Tucker Carlson, Rachel Maddow. They're defamation cases, maybe 40 filing, 40 docket entries. Here, we're almost at 70. Yeah. And we're only at step 1. Remember, they went through the whole thing, right? It was dismissed, and they went home, and they're finished with their case. Here, we're still at step 1, and we're at like 70 docket filings. 4 declarations from the defendant. Now, I want to make this very clear. Why is the declarations from Katie Joy Polson so extraordinary at this particular point in time? Well, only thing it does, it puts the defendant in more trouble. Why am I saying this? Because there's no reason for the defendant to be filing any declarations. Why? Well, because even if the defendant says everything the plaintiff is saying is not true, that can be considered an answer, right? That could be considered an answer. Why? Because you've officially said it doesn't matter what she's saying if it's true or not. So there's no need to put a declaration in saying that the plaintiff is saying is not true. Does that make sense, Kurt?
Makes total sense. If this ultimately winds up burning down to the ground because Brown filed an affidavit from Katie Joy in the motion to dismiss, which right away, as Nate points out, is kind of bizarre. And there was a sentence in there that said, to the best of my knowledge, I'm paraphrasing slightly, to the best of my knowledge, I have no subscribers or viewers from Washington. And if the judge views that as contradicting the facts or arguing facts, that one sentence could cause $150,000 to blow up in smoke. So yeah, there's a lot of possibilities here. So yeah, you're not supposed to, the very fact of submitting an affidavit or a declaration from the defendant along with a motion to dismiss seems bizarre because all they can do is argue facts. I mean, they're not a legal expert. They can't argue law. All they can do is argue facts, which you're specifically not supposed to do. So why are we here? So it's weird at best.
So I know we're 12 minutes in, and I'm going to try to get to we're going to get to the document in like the next 5. And I know we've been teasing it to death, but I think this is important to understand how we got here. So we've had the motion. So we had, Toddy saying, you, Katie Joy, did a bad thing. You defamed me. Katie Joy didn't say that didn't happen. I didn't defame you. She said, this court doesn't have jurisdiction, right? So it doesn't matter if I defamed you or not. So the court now looking to see if it has the authority to rule on this case to even have this trial. So in between that, Saltz then goes out, right, to respond to the motion to dismiss, which he has a legal right to do. So in his response, he says, well, Katie Joy has minimum contacts with the state of Washington, and then you get the Lori-Ann bombshell, right? The Lori-Ann declaration. She's flipped. Here's the minimum contacts, right?
Yeah, could be.
Boom. Right? So now you have more allegations saying that these are the reasons why. Now, to be honest to be fair, they can say, okay, that's not true. She doesn't have those contacts in the context of the motion to dismiss, right? And this little factual context, but then you'll say, okay, but even if that is true, if she did pay her and do this or whatever, is that enough to hold her into a Washington court? So the court's really going to have to decide this. Now with this back and forth, but now this is when we get to the Brown. Either he's a legal genius or he's a maniac who I don't know where he got his law degree from.
Or a little bit of both.
Or it could be both, right? So Brown could be playing, I want to be very clear. Brown could be playing 10-dimensional chess, and I just may not know it, right? I just might just be like, damn, this guy got me. But
yeah,
from my understanding, it looks like a mess. So Brown then comes forward and says, well, you know what? Since Lori-Ann flipped like Sammy the Bull Gravano in a mob case, right? She flipped like a fish on us. We're going to tear her down, right? So how are we going to tear her down? First, we're going to send a motion in to sanction Saltz, because Saltz talked to her and he should have reasonably believed that she was my client. Boom. Throw it on Saltz. So now throw some fire out there on Saltz. Then Brown, I'm thinking, again, this is all assumptions. I'm thinking Brown, after he filed that motion, he's picking up his big boy pants. He's feeling good. He's like, yeah, Saltz is going to have to feel it now. Then he probably went and probably thought, well, damn. Lori-Ann is an adverse party to me right now, right? Because all the shit that she's saying is adverse to Katie Joy. So if I was representing Lori-Ann, who's now anti-Katie Joy, and I'm representing Katie Joy, I'm essentially on both sides of the aisle, right? I'm with the defendant and I'm with the plaintiff. Looks like a conflict of interest just on the face of it, right? Lori-Ann is saying X. They have declarations from Katie Joy saying Lori-Ann is lying. It's Y. That's a conflict of interest. And Brown was representing them both in the same action. So Brown says, well, damn. I now need to have the court make sure that I'm good to continue representation. So then he puts another declaration in. And what that second declaration? It was a declaration to qualify counsel, right? To say, so the court can say, Brown, you are okay to continue on with this lawsuit, even though. Now, Brown's excuse for this motion to qualify counsel was that he didn't want Saltz hiding out in the background, chilling, right, waiting and hitting him with the motion at the right time. Boom, disqualified right before trial. And he's like, "Oh my God, you should have hit me with this before." Right? Am I speaking truth here, Kurt?
Preach it to me, baby. Yeah, all truth.
So then, so Brown hits with this motion to qualify, and then last week we had the response from Saltz. Obviously, he totally eviscerated the motion to the motion for sanctions. The motion for sanctions should be withdrawn. He just totally eviscerated that. And then we move to today, which is his response to the motion to qualify counsel. That was a lot. Did I do a good job in explaining how we got here?
Probably as good as any, because this case is a cluster that doesn't make any logical sense or reason. So, yeah, pretty good.
This is John O'Brien agreed. Evidence in a motion to dismiss is bizarre. But even if converted to an answer, PJ is likely preserved as an affirmative. Yeah, personal. That's true. I agree with that. But then you also get the bite of the apple for the summary judgment too. Because let's say, for instance, you make those allegations for the motion to dismiss, and then you find out that evidence was no good or whatever, or it could be.
I don't understand this comment the way it's phrased, because personal jurisdiction as an affirmative defense. When you say something is an affirmative defense, you usually mean on the merits. You mean that you mean that yes, I did it, but I'm not guilty because of X. So I don't understand this the way that's phrased.
Let me see. Well, personal jurisdiction. All right. So what are the affirmative defenses are? Statute of limitations, failure to state a claim, personal jurisdiction. Those are known as affirmative defenses. You raise them or you lose them.
Okay, fair enough. Yeah.
So I'm assuming he's saying that after she answers, he can still raise them again but since they've raised them already, if they lose and this is converted to an answer, you can still raise them again on a motion for summary judgment, right? You didn't have jurisdiction, and now we've delved into the details. That's what I'm assuming that this person's going with.
I don't think that's true, though. Once you're in an answer, once you're doing substance, you've waived the personal jurisdiction issue. I don't think you can bring it back up again.
Possibly. I don't know. I'm assuming you can't, but
yeah,
because you can for failure to state a claim, you can though. Because let's say if you do failure to state a claim, then you go to the facts and you find out some of the facts, you don't have. That's the motion for summary judgment. It happened in the
Yeah, I mean, effectively, that's equivalent. Yeah, motion for, or at least practically, because you're saying if everything is true, then I still win.
Yeah.
So every fact that's in dispute, I still win under those facts. So yeah, motion for summary judgment is similar. The only difference between the motion to dismiss and the motion for summary, it's a slight difference, because in the motion to dismiss, you're assuming everything the plaintiff says is true.
Yeah.
And in the summary judgment, you're assuming everything that's not a material factual dispute is true. And there's a slight nuanced difference there.
Yeah.
But the personal jurisdiction issues, once you're answered and once you're before the authority of the court, you can't say you don't have authority over me. If it were subject matter jurisdiction, you can argue that anytime. You can argue that for the first time on appeal. You can bring that up anytime. I even saw once, and I can't remember the case that it happened. I even saw once the Supreme Court bring it up themselves, sua sponte, for the first time themselves during oral argument, and then decide the issue on that. Because if you don't have subject matter jurisdiction, it's done.
Yeah. So, then you actually have no authority to actually hear.
Yeah. So I was like, oh, okay. Well, we're bringing that up issue for the first time. But yeah, personal jurisdiction is definitely waivable. If you don't use it, you lose it.
Yeah. So right now we are about to go into the meat and potatoes of this now, right? So just so we all understand where we're at, Saltz is now responding to Brown's motion to qualify himself as counsel, right, and his law firm, because he wants the court to find that he didn't have a attorney-client relationship with Lorianne Bonhart, and that's effectively, so he should, and that she also waived all attorney-client privilege. But also, I want to make it very clear too. There's the wrong belief that attorney-client privilege is only when you become my client. There's a duty of confidentiality and things for when you have for when you speak to clients, prospective clients. As attorneys, we owe duties to prospective clients too. So, for instance, there's a famous case. I'm going to teach you a little law today. There's a famous case in West Virginia. It's a coal country case, a coal company case, where the coal company, there was an accident at one of the coal plants in this town. So what the coal company did, understanding that there was going to be litigation, they had their representatives go to every local lawyer to seek representation, and then send that lawyer some details of the case. So every local lawyer, every lawyer who would be familiar with it in that jurisdiction, they went and said, hey, this is this. What that did is that when the plaintiffs now went to go look for a lawyer, all those lawyers were disqualified from representing those plaintiffs against the coal company. Like I think they did it for like the nearest like 100 or 200 miles. Brilliant strategy, right? Because now you got to have a lawyer who's traveling hundreds of miles to do this, and it's going to be harder because the lawyers in the neighborhood are closer. So just by having those consultations, so the Supreme Court came out and said, well, you can't do that, right? You can't effectively just use this rule and disqualify all local counsel just by going and doing this. And obviously, if you're a local counsel and the big companies coming to you say we may want you to represent us, you're going to bite that apple. So everybody bit the apple, and the Supreme Court said, no, if you do this and it seems, and you are doing this for this reason, disqualify all the local counsel, then you just harmed yourself, because we're going to allow local counsel to represent these people. And you can't do that. So that's one of the cases in which the rule was tested, but there was this exception. And the exception is if you're trying to blanket, an area so nobody can represent. Did you read that case when you were in law school?
I did read that case. I forgot it was a coal mining case. For some reason, I thought it was a divorce case. But yeah, I remember the essential conclusion. About the end conclusion that because they tried to recruit everyone, the court said no, we're not. You have your picket council go nuts.
It was like kind of like, that's pretty dumb that you guys did that, but okay, it is what it is.
That's creative. I don't know if it was dumb, because I don't think there was anyone telling them they couldn't do that beforehand. So
Yeah. But now it's unethical. Now if you do that, but now don't forget, if you do that now, and then it can use all this. It was actually worse for the coal company, because now they had these lawyers who did know this other stuff, and it was like they were free from the conflict of interest. It was good for the plaintiffs, bad for
that would be such a nice little burn for me as a lawyer. I don't know why I'd get so much schadenfreude from that, but if someone like gave me this confidence, and normally my ethics would of course prohibit me, but if somehow like the court said because of XYZ you get to use this information specifically to burn them, I don't know why that would bring me such pleasure. I could use this to destroy you for trying to manipulate this. Let me tell you about the things you told me at confidence in detail. Like you did an affidavit.
Like you guys went to every attorney in 100-mile area. Really? Is that reasonable? No. So anyway, the reason why I speak of that, because we as attorneys, if I'm consulting you, and I'm careful when I do this too, and if you start telling me all the facts of your case, and you tell me things that are I have to keep that confidence, and then it bars me from taking an adverse position from you. So that's what could happen when you're talking to people who are prospective clients. So that conflict of interest is not only if you represent them, it's also if it's a prospective client, prospectively represent them. So I need you guys to understand that Lorianne didn't need to be his client. She just needed to be a prospective client, and she just and only thing she needed to convey to Brown is any information that's personal that Brown couldn't share with everyone else, and that would then bar Brown from taking an adverse position against Lorianne. But
one note here: if Brown had immediately said, it's not quite the case that if someone just dumps this information on you, you're bound by it. So if you could always just say, well, I'm not a lawyer, I can't represent you if you do it immediately. Yes. So there's a note there. Of course, Brown didn't do those things, so it doesn't matter. I just thought I'd bring up
you're 100% right,
because every rule has exceptions. So why not bring them all up at once? No, so we confuse everybody all the time.
So just to be clear, if Brown is prospective client, if Lorianne's a prospective client, if she's telling him information, he can still be Brown. Now, he can still be barred. So, but also, I just want to make everybody clear: if Lorianne and KJP, if they're on the same side, if they are friends in the lawsuit and they're helping each other out, it's okay for Brown to represent them both, right? She's a witness. She's not even a party to the suit. But if she flips, then you may have this issue. Because if she flips now she's an adverse party, and now you may have this conflict between someone on both sides, and that's where you get the saying, clients can flip sides, but lawyers can't, or litigants can flip.
See, I think also here I have to slightly disagree with you here that she doesn't become an adverse party because, strictly speaking, like
she's not a party.
A witness doesn't really belong to either side because anyone can call anyone. So the witness might be called by one side or another, but slightly error to say the witness belongs to one side or the other.
All right, that's true. Yeah,
they're the witness for the common. So yeah, there's that, but
the witness becomes adverse to one part, to one side, or whatever, because it does. Witness can be adverse.
That's fair. That's fair enough. Mm-hmm. Yeah, I mean, the witness could be adverse or helpful, and. Yeah, I probably wouldn't call a witness who's adverse to me, but theoretically, I guess I could. So there's something.
The hostile witness. That's what.
Well, no, not just hostile. I mean, actually adverse. Like they have negative things to say.
Yeah. And that's what Lorianne is.
Negative things I have to say. It's not just that they don't want to testify. It's that if they did testify, it's going to hurt me. I'm not sure why I'm calling this witness. Some sort of massive brain play about really drawing out that sting theory, but I don't know about that.
So now. Since we've touched every little thing a little bit, right? So we've talked about attorney-client. We talked about you don't have to actually be the client, but perspective and all this other stuff. So we've talked about it, and I wanted to put you guys in the right mental framework. So when we read through this, it'll be nice. It's a nice, easy read, and now you understand how we're thinking about this and why we respond to certain issues that are raised here the way we do because of this knowledge that we've just bestowed upon you. And again, super chats are welcome. And we hope that, this first 30 minutes of background just was to help you understand why we're going to be responding the way we do and why we're looking at the document the way we're going to be looking at it. So without further ado, let me pull this thing up. And great thing is only 13 pages because 13 pages we can do. Boom. Here we go. Right up at the top. So this is the bomb. This is now one thing, 26-line paper. 26 lines, baby. Boom. Saltz is on it right now.
Saltz can count.
45 versus 25. Add an extra 21. All right, so this is the introduction. Before defendants have filed an answer admitting or denying any of the allegations in the plaintiff's complaint, Attorney Michael P. Brown and defendants are seeking a blanket order from the court that Mr. Brown and his law firm cannot be disqualified now or ever as counsel in the instant litigation or future proceedings in another forum based on his conduct related to non-party witness Lorianne Barnhart. So right off the bat, Brown explains to us what's happening, right? They haven't even answered. Saltz.
I get confused all the time too. I was watching my own stream back, and sometimes I was saying Lorianne when I meant Katie Joy, and sometimes I say Brown when I mean Saltz. So sometimes it's hard to keep it all straight.
Oh yeah. But this is Saltz. But just to be clear, this is exactly what we're saying, right? Nobody's even answered the complaint. So this is qualification motion may even be irrelevant, to be honest with you, because if the court doesn't have jurisdiction, let's say the court finds it doesn't have jurisdiction, then what the hell are we doing? Then there's no reason to qualify or disqualify you, right? It just doesn't matter because there's no case to be qualified for. So, but again, we'll get into that because I think Saltz speaks to this later. So the defendant's motion to qualify, which should be denied because such a motion is inappropriate. The issue of disqualification is not yet ripe. Discovery is stayed. The totality of the circumstances between Mr. Brown and Ms. Barnhart is unknown, and the requested release is overbroad. Defendants failed to cite any legal standard for which the motion to qualify, which is true. I went back and looked. I didn't see one, nor did they cite a single case in which a party has successfully requested such release from the court, which is again true. Perhaps that is because there is no such perhaps it's because it appears no such case exists. The lack of such case law is likely because once admitted to practice before the court, attorneys are not required to affirmatively prove they're qualified. That is true. It's I've next. Have you ever seen that? Have you ever seen an attorney?
No, this is the first time I've ever
qualify.
This is the first time I've ever seen it. Because it's an all-time first, but it sounds pretty weird.
And let's say if you weren't licensed to practice in that jurisdiction, you've just committed a crime, right? Because it's illegal to practice law without a license, right?
Usually,
so yeah. So I don't know. It's you'd have to be qualified. Is it possible that Brown is trying to get out of this suit? If it is, this is one hell of a way to do it. If this is one hell of a way to do it, because the way this reads, Brown may have ethical problems with the ethics board. Like I could actually see that happening here. I can see Brown really having an ethics problem with the ethics board, based on what I'm reading here. But we'll get into that in a couple of seconds. Let me just read through this preliminary stuff. Once admitted for the court, rather, counsel is presumed to be qualified. Rather, counsel is presumed to be qualified and eligible to practice before this court until 1, counsel withdraws. That's true. 2, the court exercises a duty to examine charges of a conflict of interest brought in a motion to disqualify. That's true. And determines that counsel is disqualified. So that means, the court finds it. And then the defendant's counsel, Mr. Brown, has not withdrawn, and no motion to disqualify Brown has yet to be filed in this matter. So in other words, if the other side brings a motion to disqualify, then yes, you can, it would be appropriate. But no one's brought a motion to disqualify, nor has Brown even withdrawn. So that's what they're saying. They're like, where does this motion to qualify come from? It's just something he just made up. And to be fair, lawyers do this sometimes. I have seen lawyers bring up like wild motions. Like, what the hell, motion for a sandwich? What are you talking about? But it happens. You wanted to say something?
No, I'm fine. It's just my eyes really itching. Go ahead.
So on January 13th, 2021, Ms. Barnhart submitted testimony against defendant's interests relating to personal jurisdiction, referred to herein as the signed Barnhart Declaration. I love how Saltz makes it, just twist the needle even more. Signed Barnhart Declaration.
What do you call an unsigned declaration? Nothing. You
call it hearsay, right? Impermissible hearsay. Unless she wrote it. But if he wrote it, then it's So which one shows defendant Katie Joy Paulson misrepresented the nature and scope of defendant's Washington contacts in her declarations, which she shouldn't have filed, in support of defendant's motion to dismiss, and establishes defendants have sufficient minimum context of Washington. Again, that's a legal conclusion. We don't know if she had sufficient minimum context. I don't think they do, but Saltz is trying. Now, this is good legal writing, though. Saltz is trying to throw it in the defendant's mind. Like, what I think Saltz is doing here is just saying it, so it's almost like a nothing. Like, of course, there's minimum context, right? This is the reason why it establishes minimum context, but it doesn't, right? What do you think about that?
No, I like it though. You just like pretend that it's true in the hope that no one notices, and everyone just assumes it's true. I like it. Works for me.
Yeah, The defendant establishes that the defendant have sufficient minimal context. No, it didn't establish that. It is helping, but it doesn't establish that. But again, this is the way you should write these things. If you're a wannabe lawyer, you should write them like this. This is perfect because it makes it seem like it does, but it doesn't. Although it appears from the correspondence between Ms. Barnhart and Mr. Brown, over 150 emails and 2 phone calls, that a reasonable person would have the subjective belief that an attorney-client relationship existed. So now I think Brown here is pulling a double blind. What do I mean by that? I think Brown, from my reading of this document, I think Brown is building up the whole attorney-client relationship, but then at the end slips in the lower standard of, hey, you don't even have to be an attorney. You don't have to have the relationship. You just have to be a potential client, and you get these conflicts, right? But by building up the higher standard early and saying we even meet that, but they're slipping in the lower standard, it's like, okay, this is obvious. What do you think?
No, I like it. Yeah, I like it. It works for me.
Super chat, do you think witnesses should always retain their own counsel? No. I don't. It really depends. If you're a witness who may have some liability, though, of course. But if you're, because again, you don't have to be a witness, right? Unless they maybe subpoena you or something like that. And then if you're forced to testify and you think you may have some liability, then you should get your own. You should get a lawyer. Does conflicts like this happen often when the defense is questioning witnesses? No, because usually it's clear that I'm not your attorney. I'm this person's attorney, and I'm trying to do what's best for their attorney. If the lawyer is trying to represent both the witness and the defendant, that's when I think you get these issues. What do you think, Kurt?
Yeah, I mean, I think this is right on the money. It's the right argument. It's persuasive. It's well written. Saltz knows what he's doing.
Yeah. Let me get back to the doc real quick. Thank you for the super chat. So as we continue to go, let me pull this back up. So we had 150 emails. Attorney-client relationship existed. A determination of Mr. Brown's qualifications to remain counsel in this matter due to his conduct with Ms. Barnhart is premature. Defendant's motion to dismiss regarding personal jurisdiction is still pending before the court. No answer. Affirmative defenses other than raised in a motion to dismiss or counterclaims have been filed identifying the issues in this case, and the discovery in this matter is currently stayed. So Brown is saying that a motion to qualify counsel before the motion to dismiss has been put forward. Doesn't make any sense, because if the court grants the motion to dismiss, there is no case to be qualified for. Do you agree with this reasoning, Kurt?
I mean, it makes perfect logical sense to me. I think Saltz has the better end of the argument. There's some argument to the contrary, but yeah, I mean, ultimately it's premature because you can't know for sure if it's going to come up, because Lorianne's value appears to be limited to jurisdiction unless there's something we don't know, which is definitely possible. So her value in jurisdiction is as a subscriber, viewer, one, or as agent, two, if you buy that. Her value, the only reason that she would ever appear on the stand or be a cross-examined or really appear in a deposition during discovery is if she has something to offer on the facts, if she's a fact witness. And so the only really way that I see that happening is if Katie Joy said some incriminating things relevant to this to Lorianne at some point, in which case Lorianne's value goes up immensely. Otherwise, it's not clear that she has much value as a witness. So it's not clear that she would appear in discovery. It's not clear that she would appear on the stand. So yeah, the issue may never materialize.
Yeah, and let's not also forget too, the core point is that you have to take these in steps. If the motion to dismiss is granted, that the court doesn't have jurisdiction, then this motion to qualify counsel again is moot, right? It's irrelevant, right? Because it's not like they're going to have to figure out if he's qualified for a case that doesn't exist anymore, right? It just doesn't make any sense. So I think Saltz, I think, like you said, Saltz has the better, I think, legal argument. And just if you just think about it, just practically, he has the better argument here.
And also, to be completely fair, I don't 100% see the big problem at the end of the day, even if there is a conflict, because if there's a conflict, that just means that Brown and maybe his firm can't cross-examine Lorianne. So presumably you could have some different counsel for that limited purpose to solve the conflict, and it would be fine. So I don't think it's the biggest massive deal I've ever heard of in my life. So I don't think she's going to be thrown off the case completely to solve the conflict. Seems like there's easier ways to solve it.
I think what you're saying is accurate in the sense of even Lorianne right now is just strictly for the motion to dismiss. So the motion to disqualify counsel for a witness who who is not really a fact witness, who's not a witness that you're going to have at trial.
As far as we know,
a witness is limited to this one issue, which is already on the table, right? Which is already on being decided. So even if it's decided against you, or even if it's decided for the plaintiffs, where it goes forward, Lorianne may not be irrelevant to any of the facts. She's irrelevant to the defamation piece of it. So if that's the case, then this motion to qualify makes no sense, even in that sense, right? Because Lorianne is not going up there saying, Katie, like Kurt was saying, Lorianne is not going up there saying, I have this evidence that of this defamation. She's only going up there saying, this, I was just here for minimum context. That's it. So that's why Brown's motion, again, it just doesn't make any sense at this particular point in time. Even though before I thought it did make sense, but then I went back and said, no, it actually doesn't. And reading through this, it doesn't. And Nate, the lawyer, would there be ramifications if there is a conflict? Yes. There could be. They could be, especially with his board, because the ethics board can easily. I think this is easily something that can go before the ethics board.
I'm not sure that I see the ethics issue with respect to the things that happened when he was talking to both Lorianne and Katie Joy, because at that time there was no conflict between them.
Agreed.
And so I don't see ethics violations for that reason.
Well, no, I'll go where, again, I don't believe I don't believe he's committed any ethics violations, right? I don't have any evidence of that. I'm just saying the way things are coached here, I can see an ethics violation be materializing based on some of the stuff that, and we'll read it a little later. Well, I would be concerned if I was Brown that, oh my God, we may have an ethics issue here. Let me go back to this. Okay, so until the pending motion to dismiss is decided, which we've just been talking about, defendants have answered plaintiff's complaint, again, which is true. It is unknown whether Ms. Bernhardt, again, so he's saying the same thing we just said, right? It's unknown if she's currently a witness on a jurisdiction issue, will be deposed. So he said, this is, again, I'm not going to read through this because this is exactly what we just were saying, right? We don't know if Lorianne is even relevant. So we just actually said what he just wrote. Additionally, the court currently does not have all the facts to affirmatively and indefinitely qualify Mr. Brown as counsel. Agreed. Although Mr. Brown has provided the court with a conundrum, what's it? Compendium? That's compendium, right? Oh, sorry, let me highlight it. Compendium of his emails. That's compendium of his emails, of his email communications with Ms. Barnhart. He has not represented that he provided this court with all his communications with Ms. Barnhart. Now, here, this is where I'll even I don't want to be critical of Saltz in this way, but my issue is that if she was a proposed client, I wouldn't give you all her communications if I was her, if from that issue, because you can't, right? Let's say she came in, and as we'll see later, she's asking for legal advice and this, and you're giving her this information as a proposed client. Now you still have that duty of care, right? And you got that duty, now you can't just give her. So Brown can't release all her emails to the court because that would be violating the rule for the proposed client.
Yeah, he kind of did that though, didn't he?
But then, so that's what I'm saying. It's like she's a proposed client. She's giving me information. Now that information I got to treat as attorney-client privilege, right? Because she's a proposed client. So here I'm saying, okay, well, here's a couple of emails just to put the point, limited in scope because of this relationship. But now Saltz is saying, well, you didn't give us all of them. But I didn't give you all of them.
It looks suspiciously like pretty much everything. I mean, it looked like everything except maybe a limited few, less than 5 maybe for some health reasons. It looked like pretty much every email. I guess what would not be included here would be records of telephone calls or records of in-person meetings. So that would be other communications that would not be reflected by email. So maybe there's those kind of communications that we could be talking about.
Yeah, so, and you're right. It says all communications, but I'm saying if she's a potential client, you wouldn't give all the even if that's true, you wouldn't give all of it. So I understand what Saltz is trying to say. Unless we have them all, we can't really determine it. But I don't think that's true. You would also, the court isn't justified in getting them all. Only the ones relevant to this particular issue. You know what I'm saying? To the issue of this. So
I mean, presumably he could give them all to Saltz because Saltz is now her lawyer. And so
no, Saltz is not her lawyer. Saltz made sure clear he's not her lawyer.
Well, he did prepare a declaration and get her to sign it.
Yeah, but that's not being her lawyer. That's, you do that for witnesses. That doesn't mean he's her lawyer. Okay. But I understand what you mean now. But again, I'm just saying I think Saltz is playing this one up, but I wouldn't give all of it, even if this is true. I don't think you need them all, nor do I think Brown could have given them all based on the rule. But again, that's just my little technical issue with this one. He has not represented or provided the court with all his communications. I don't think he has to. I think this is just, this is where I think Saltz is going a little too crazy, but okay. To be certain, Ms. Barnhart provided plaintiff's counsel with additional communications that are not included in Mr. Brown's news declaration. So now I think that then brings you to waiver, right? Because if the privilege is Lorianne's. So if Lorianne then shared it with a third party, the privilege is eviscerated. So now Brown can turn them all over, right? Does that make sense, Kurt?
Yep.
So what I'm reading here is that Brown turned over some communications. Lorianne turned all of hers over to Saltz, and Saltz kind of holding them like, yo, you didn't turn over everything. You know why? Because I got them all. And you didn't show them all.
Well, the way I read this, because I was trying to read this, where it says, okay, has not represented he provide the court with all of his communications. That's one thing. And then the second says, to be certain, Ms. Barnhart provide plans counsel with additional communications that were not included. But that isn't saying those additional communications are communications with Brown. They're just additional communications. So I was wondering when I read this, I was thinking, well, what could that be? And what I concluded it might be referring to was the Twitter stuff, because it looks like Brown never got access to Lorianne Barnhart's Twitter or her DMs, and Saltz did. So those would be the additional communications. They weren't communications with Brown, but they're additional communications relevant. So there's a slight linguistic thing here where it says you didn't provide us with your communications, and then you said didn't provide us with all the communications, but that doesn't necessarily imply his communications, or that's the way I read it.
Oh, interesting. I don't know. I don't think this all communications thing is necessary. I think he's playing it up, but I think his argument is stronger at the end. I think this was one of the weaker arguments in this response, but I think it's good to set the stage, but I don't think it's necessary.
I just want it to be noted that you can obviously interpret this referring to Brown's communications with Lorianne. That's a fair interpretation. But at least to me, I read a slight nuance point in here, and I'm like, I wonder if we're being a little bit clever with our nuance here. So I'm on to you.
So here it is. There is no question that Mr. Brown now has a conflict of interest regarding Ms. Barnhart. The record reveals that Mr. Brown has repeatedly attempted to discredit Ms. Barnhart's testimony, truthfulness, and mental competency. That's true. Despite his own efforts to use Ms. Barnhart's for her testimony on behalf of defendants, as recently, I like how he underlines it, as recently as 2 days before the signed Barnhart declaration was filed. So in other words, he's saying she's untruthful, she's mentally, he's challenging her mental competency, all this bad stuff, he's trying to discredit her. But here, and again, I got to play devil's advocate for both sides. Here, I think if she's working with me up until this point and says, and she says, yes, the car is red, and I fill out a declaration saying the car is red, and then 2 days later, next thing I know, she signed a declaration with you saying the car is blue and was never red, then I can, I'm going to challenge, that I'm going to say, of course, something's wrong, right? I'm going to try to discredit her. I'm going to say something's truthful. I'm about the mental competency, may not be, but I don't see anything wrong with that, because that happens all the time. Witnesses say one thing and then they'll change their story. Now, I'm not saying Brown can't bring it up, but I'm saying that it's not that weird for that to happen, that witnesses change their stories. Do you agree?
Yeah.
So, but I don't think that may hurt Lorianne's credibility, because I know, like, in your eyes, Lorianne's credibility is shot. Right.
Well, yeah, I mean, she made wildly inconsistent statements to Brown versus what she said to Saltz, and Saltz did a very good job in his earlier filing of showing why he thought every statement in the declaration was supported by evidence. So he did a very good job of showing why it was all supported and why it all has some validity. Its ultimate truth, I suppose, is still somewhat up in the air. But even if everything in the declaration is true, it still means there's a difference between saying that Lorianne is credible and saying the declaration is true, because even a non-credible person can tell the truth. A liar can tell the truth. It doesn't mean that you necessarily will believe them going forward. So there is a distinction there. So yeah, the fact that she told an inconsistent, and in my view, directly inconsistent statement to Brown, unsolicited, means that her credibility is shot. Even if she's telling the truth in her declaration, she still has a credibility problem. So it's like, I'm going to look at it a little bit more skeptically as a result.
Of course. That makes great point. They clearly disclosed in the last Saltz filing that they told Lorianne that they weren't her lawyers, etc. So I remember that. Yeah. Good point, Haley. Thank you for that. So let's get back to here. Barnhart's testimony. Oh yeah. So I don't think, when I first read it, I thought it was bombshelly, but it's not really, because witnesses change their story. And so what? I believed her. Then she started saying things that were different than what she said before. So I'm going to try to discredit her. So I understand what Saltz did. Saltz is trying to say, well, she was good enough for you to want to work with her, and then when she said something you didn't like to hear, now you discredit her. And that's the way the game is played. Like, you just got to be adults. You know what I'm saying? The way the game is played is, when she was saying what I liked, it was good. Then she said the exact opposite, and now I'm trying to discredit it because she told me something different before. That's just the way the game is played. I think so. I don't think this is as big as some people are trying to make it out to be. Finally, the defendant's motion to qualify relies on hearsay evidence. Mr. Brown's correspondence with Ms. Barnhart, yes, that would be hearsay. And 2, Mr. Brown's correspondence with purported relatives. Oh, yeah, that's definitely hearsay.
That's definitely hearsay.
Yeah, the first one, Brown's correspondence with Barnhart, you can. It all depends on what it's coming in for. If it's coming in for the truth of the matter asserted, yes, it's hearsay. But I think it is coming in for the truth of the matter asserted, because if he's saying what she's saying in those correspondence was true then, this is true, and what she's saying now isn't true, then there's a are you bringing in to impeach her, or are you bringing in for the truth of the matter asserted?
Impeach her, because that way I get it in.
But if you're all right, so you're bringing in to impeach her. But then you could technically make the argument you are bringing in for the truth of the matter asserted, right? You're saying that what she said then is true, and what she's saying now is false, right?
The jury might draw that conclusion. I have no opinion on that.
But again, the hearsay argument, I think, is something the judge can work out. In light of these issues, plaintiffs were not and are not in the position to speculate on Mr. Brown's request to retroactively remedy his conflict of interest with his former client. Obviously, you see the burn here, right? With his former client, Ms. Barnhart, for the same reason the court should deny defendant's motion to qualify. So Saltz is really good at writing here, because he's using about any conflict with his former client, puts in the reader's mind Barnhart is the former client. It's this is a masterclass in persuasive writing, I think, from Saltz. What do you think?
Yeah, I mean. Yeah, I agree completely. The emails were certainly not clear in any respect that Brown was not representing Lorianne. There was one statement that maybe obliquely, if you tilted your eye and squinted your eyes right, could be possibly read to be that. But the overall tenor of the emails was like, I will stand for you. You don't need to worry about this. I will handle it. Here's some things you should do. Here's some actions you should take. So it's like, yeah, that kind of looks suspiciously as if a person could interpret that as legal advice. So yeah, 150 emails and phone calls over 18 days of correspondence without you ever saying, I'm not your lawyer, I'm not representing you. That's kind of a problem.
Well, hey, it's like you read the next line. So nearly 150 emails and 2 short phone calls over the course of 18 days. Now, I think Brown has a great response to this, right? Because how many times did Saltz and his team, remember they were on the phone with Lorianne for 11 hours in one day, right? So he could also put back, well, if you're talking about the amount of contacts you got with somebody, Shell, you were on the phone with the woman for 11 hours in one day.
And then Saltz's reply is that we weren't so stupid as to not say that we weren't her attorney. We kind of made a note of that several times.
But now people, you can understand how this can go back and forth, right? Like Kurt is 100% right. But here, it's just if you're just saying, well, because 150 emails and 2 phone calls means that it can lead the person to reasonably believe that they were your client. But the response can be, so she must have thought, but then as Kurt rightfully said, we made it abundantly clear that we did not represent her. And that's what you would look for. Any email or correspondence say, I am not your attorney, you do not have this relationship, and then the person can't say, I didn't know. And that's kind of what this is hinging on. Did Brown ever notify Lorianne that there was unequivocally he was not her attorney?
Not in writing, that's for damn sure.
None of these communications established that Mr. Brown advised Mr. Barnhart in writing that he did not represent her or that he was not providing her legal advice.
Yep.
The nature of the approximately 150 emails that have been produced by Mr. Brown revealed that he provided Ms. Barnhart with legal advice relating to 1, alleged harassment she received on Twitter following the filing of the declaration of Kim Fulmer. 2, she should respond to plaintiff's proposed subpoena. And 3, her proposed testimony in support of defendant's motion to dismiss in this matter. Go ahead.
I'd like to comment on 3 here because Saltz is arguing that Brown provided Barnhart with legal advice by preparing testimony in the form of the declaration that was going to be submitted. But if preparing testimony in the form of declaration is legal advice, then my question goes back to you, Nate. how is Saltz not her lawyer? Because wouldn't that also be legal advice? Here's the declaration I'm preparing for you to sign. How's that any different fundamentally?
That's true, but the thing is that I've prepared declarations for witnesses before, but I've told them, you're a witness. I'm not going to, this is, and just so everybody understands the way the game is usually played with this is that for a witness, I'll prepare a declaration. I'll send it to the witness. The witness will read it, right? Blah, 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 blah. But in that back and forth, the witness knows you are not, I don't represent you. I represent someone else. But you are a witness to the case, and here's what you're saying. If this is true, right? You're signing it under penalty of perjury. But you have to make sure you tell the person, I am not your attorney, right? I am not your attorney. So the difference here is that if all of these things are true, would a reasonable person not being told because that's why I think he started off with saying he never told her in writing that he wasn't her attorney, and these are all the things that he did. So would a reasonable person believe that you are not their attorney and you did all these things? You know what I mean?
Yep.
So I think that's the distinction here is Saltz specifically said, I'm not your attorney. Brown never really said that. So if that distinction makes sense to everybody.
Yeah, works for me.
So here, additionally, the primary reason Miss Barnhart contacted Mr. Brown was to solicit his services to correct the record as to her employment. So this last sentence, I think, starts putting us into the proposed client, right? This is a person looking for representation, and as a proposed client, Brown now owes her a duty of loyalty, and he has to keep her communications private. What do you think about that? Right? If she's soliciting his services, that's exactly what a proposed client is, right? Am I wrong with that?
Nope.
In a signed Barnhart declaration, Ms. Barnhart testified that Mr. Brown offered to represent her as third-party witnesses, as a third-party witness in the litigation. So again, if he's offering to represent her, she seems like she's a proposed client, right? She's seeking representation. It seems like we're right down that path, right? She's a soon-to-be client, possibly. Ms. Barnhart also advised plaintiff's counsel on January 12, 2021, that she believed Mr. Brown was acting as her attorney because she repeatedly asked him for legal advice, which he provided. Providing legal advice, she subjectively believes that he's her attorney, and he offered on multiple, occasions to help her at no cost. I'm going to say it. It sounds like Brown is representing this poor woman, Laureate.
That was the conclusion I came to.
It sounds like this is representation.
Yep, I'm told.
I gotta ask people in the chat.
The one that put me over the top was when Brown said, "I will stand for you." That was the one that put me over the yeah.
Oh yeah, he did.
That was the one that put me over the top. I'm like, yeah, I'm done.
Oh my God. All right, listen. All right, people in the chat, put the number 1 if you think Brown is represented Laureate as her attorney, and put 2 if you think he did not. I'm going to start it off. I'm going to put a 1 because it seems like Brown was her attorney. Like crazy. Offering legal advice. At
least from Lorianne's subjective, reasonable view.
And again, the standard is if what subjectively did she think so? It seems like it's oh my God. So Brown represents Lori. Oh my God, this is insane.
When you're having this? When you're I don't know where in the chain this exactly broke, but when you're having 150 or whatever the number is, it doesn't really matter because whatever the number is, it's big. When you're having a number of emails back and forth and talking about legal stuff, at some point it should occur to you as a lawyer, wait a second, what is the nature of this relationship? And apparently that thought never crossed Brown's mind or something. So I don't know, man. Yeah.
There's not a 2 in the chat. My God.
No.
This Brown's in trouble.
It's pretty bad. Well, I mean, the nature of a potential conflict, which again, I don't think has matured. But yeah, there's a potential problem that is brewing someday.
Here's Ivy Boss, Nathan Lloyd, paralegal here. Hey, welcome. If a potential client calls to inquire if we can represent them and we determine we cannot, Then we verbally say and send them a certified letter stating, yeah, to see why. Of course. That makes sense. That
seems
makes
like
sense.
a prudent idea.
Yeah.
What if I clarify this so that there's no mistake? That seems like, oh, maybe like a good idea.
Just imagine if that letter,
maybe an attorney would think of that idea, you know?
Just imagine if that letter said, we will stand with you. You sent the certified letter and said, we will stand with you. That makes me think that you're representing them. So, oh my God. Here it is. Look, non-representative letter or email. Well, and don't forget, you can establish an attorney-client relationship without the formal letter of representation.
Sure.
The engagement letter. Obviously, I can say I'm representing you, and you can go into court right then with that. So it doesn't mean you don't need to have the formal letter. It's really, and it's a subjective belief of the person. It's not what the lawyer believes. It's with the subjective belief of the person. That's why you have to make it very clear. Let me put this to the back on the screen. Yes. All right. So let's go. Let's get through this because we're on page 6. Mr. Brown also dissuaded Ms. Barnhart from contacting plaintiff's counsel directly. For example, all right, so he gives his example here. I spoke with Saltz today. They are planning to subpoena your Twitter account because they see that you closed your account and they think that there might be evidence there about your connection to Katie. I did not disclose that you and I are in touch. Brown. Saltz even complained to me that you threatened him via DM. So Barnhart threatening Saltz, and Saltz complaining to Brown. And then Barnhart responds, so what are your thoughts? Then Brown responds at 6:22. Like they're having a conversation via email. I'll have to think about this. For the time being, it is best for you not to make any contact with Katie and vice versa. Prudent. They are working hard to try to paint you two as a team, and that's not good for either of you. Okay. Barnhart then responded in relevant parts. Maybe it would just be easier if I went to meet with Saltz myself. He can see me face to face and see I am no threat. Is he in Washington? Because I thought Lorianne was in Washington. How could she meet him face to face?
Saltz is a Washington lawyer.
Oh, all right. I thought
Saltz had much earlier in this invited Lorianne to come down to her office. I think they live in the same city.
Oh, all right. And she says I have nothing to hide. I actually present myself very, very, very well, and know how to be professional when I need to be. You go, Lorianne. And FYI, I've DM'd with Lorianne. Lorianne's cool. I've never had a problem with Lorianne. Lorianne's actually always been pretty cool. So, well, not actually. She has always been pretty cool. I've never had a problem.
You should have Lorianne on your channel, man. That'd be good for an exclusive scoop. The Lorianne story revealed, Lifetime story style.
Well, I've DM'd Lorianne. Lorianne's cool though. It's interesting because I've only talked to her via Twitter DMs and things of that nature, but she's always been cool. So I've never had an issue with Lorianne. Don't worry. I will not say nor do anything without telling you first. Why? Why would she not do anything? Because without telling him first? Because she thinks that's her lawyer.
That could be a reasonable conclusion. And again, a reasonable lawyer might look at language like that and think, wait a second, why would she be saying that? What does she think is going through her mind? Maybe a reasonable lawyer might ask themselves these questions, which apparently Brown didn't do, or something, because
Well, let's see what. Well, then Brown responds the next day in the morning, 6:37 a.m. So Brown is up early. He in bed. He like, yo, Lorianne, hit me back. Let me respond to her. I understand that impulse, but you need to understand the type of person he is. Saltz, do you have the ability to pay for your own lawyer to help you if they do issue a subpoena?
So, see, that statement in isolation perhaps could be understood as I don't represent you, although it's certainly not saying that. Because do you have money to pay for your own lawyer?
Means I'm not.
But he doesn't say I'm not your lawyer. And again, there are many, 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 many other emails that, not so much. So, yeah.
But we haven't finished, but I 100% agree. This email in isolation does make it seem like, hey, if I'm her lawyer, why the hell would I be asking, do you have money to pay for one, right? Because you already got one. If it's unclear, if Ms. Barnhart responded to the above email as the record is devoid of such response. Yet, on December 31st at 2:47, Brown wrote. So we don't know what Lorianne responded to this, but then Brown wrote this at 2:47. You'll get a copy of the subpoena if they issue it. If it just asks for the communications with Katie, then it sounds like there won't be much of it. If it's too broad, like asking for all your tweets, etc., you can challenge it.
Which is perfectly reasonable legal advice. You know, you can challenge a subpoena for any number of reasons. Overbreath would certainly be one of them. So it sounds legal advice, but it's also legal advice. So
but that's now just so everybody understands what legal advice is. If you give me a specific set of facts for your particular action, and I apply it to law to tell you how to act in that particular space, like this is happening. If this happens, these are your legal recourses under this particular law in a jurisdiction that I am licensed to practice in. That's legal advice, and that's what you get here. So this is textbook legal advice. He's telling her, if this happens, you can challenge it based on the laws in the current jurisdiction that he's licensed to practice in. Does that make sense, Kurt? Did I explain that well?
Makes perfect sense to me.
So this is textbook legal advice. Mr. Brown also convinced Ms. Barnhart on at least one occasion that she did not need to consult with separate counsel. Oh God.
This one is my favorite part. Yeah, this is my favorite of this one.
On January 8th, 2025, 35 p.m., Barnhart wrote in relevant parts, I used to volunteer at, what is it, Snornoomish? Or
whatever.
County
S County
Legal Service. S County Legal Services. Maybe they can help me. So she's saying, hey, I used to volunteer at this place. Maybe they can help me. Brown responds, what help do you think you would need from legal services? Good question.
Yeah.
She put in relevant part, advice.
Now,
true.
This is the part where like a lawyer's attention should come to mind if it hasn't already. Because like, what help might you need? Advice. So you're looking for legal advice. So what Brown thoughtfully responded to this at this point was to say, okay, well, that's good because I'm not your lawyer, so I can't give you legal advice. So that sounds like a good idea.
No, Brown didn't say that.
No,
Brown said this.
I misquoted him.
I understand. You really have nothing to worry about this.
Uh-huh.
You've done nothing wrong.
Yeah.
I think I can help you with the response for no charge.
Uh-huh.
It's very simple.
That sounds suspiciously materially and substantively different from what I said.
That sounds like a proposed client right there. That sounds like a client, a potential client.
It's like, I'd like legal advice and I can help you.
Brown, what is Brown doing here? What the hell are you doing, Brown?
Not the most encouraging series of emails I've seen in my life.
Brown,
a lawyer and who might be interested on who he is or is not representing him, might want to make that clear.
Brown is representing Lorianne. That's representing Lorianne, right? She at work.
Apparently, Brown doesn't think so because we know that from many earlier declarations with Brown. Brown said, "At no time was I her lawyer." This is definitely not a thing that ever happened.
He's virtually begging a woman to represent her and say, "Don't worry about it. I got your back for free." She's a potential client. So what does that mean if she's a potential client? She get all those protections, right?
Uh-huh.
She gets all those protections.
That would be the natural conclusion of that, yes. Brown sometimes seems to miss things.
I think Brown has a problem. I don't know what Brown's doing.
Well, I don't know how much a problem he really has at the end of the day because I'm not sure how much of a deal it's going to be. But if he's doing that in this case, it might be suggestive that he's doing it in other cases or other issues. So he might have a more global problem. There's definitely that potential.
Oh my God! We haven't even started this. So around on January 11th, is this the next day? Let me make sure what day was this. This is January 8th. So 3 days later, Ms. Barnhart terminated her relation. I like this. Ms. Barnhart terminated her attorney-client relationship. Let's make sure we just just call a cat what it is, right? With Mr. Brown. On January 13th, the signed Barnhart declaration was filed. So just get this, though. So Saltz, on the 11th, it was done. And on the 13th, she's flipped and have the, again, signed Barnhart declaration, right? Was filed. Make sure it's not hearsay. So then on the 22nd, Brown then filed a supplemental declaration. I keep saying supplemental jurisdiction. I keep about to say it again. Declaration in support of defendant's motion to dismiss, in which he purports to characterize his communications with Ms. Barnhart and accuses Ms. Barnhart of filing false statements under penalty of perjury. You can't do that with a potential client that you've honestly tried to represent. You can't now go back and in the same action, right? You can't now go back and say that you can't throw them under the bus. You understand what I'm saying, Kurt? He can't throw Lori under the bus like this. That's not allowed. Am I wrong? Because I can be wrong. Can you now throw your client? He's saying, I can represent you. I can do all this. And then 2 days later, throw her under the bus?
Well, I need to look up ethics rule 1.6 and see if I can squeeze this into something. Hold on.
I don't think he can throw her under the bus saying that she's filing false stuff, because that's it. That's done. Like,
could we say that we're revealing the information to prevent the client from committing a crime or fraud that's reasonably certain to result in substantial injury to financial interests or property of another, in the furtherance of which the client has used the services? Can we squeeze it into 1.6b2? No, I know that. No. Yeah, I know we can't. No.
What the hell is Brown doing?
Prevent, mitigate, or rectify substantial injury to financial interest or property that resulted from client's commission of a crime.
None of this works. Brown, what are you doing, Brown? Brown can't throw his client under the bus. Now I said the woman he's just begging to represent is now committing perjury. No, Brown, no. That's, I don't know.
I don't understand. She's committing perjury from things that she told me in a confidence. That might be a problem.
Might be a problem. That's not allowed at all.
That's why it might be a problem.
My former client lied.
Uh-huh.
And I know it because she told me so in confidence.
Also, I literally know where the bodies are buried. Would you like me to tell you?
Just imagine, think about this, people. Think if this was a criminal case, right? And the attorney is saying, yeah, my client's a liar, and this is where the evidence is at that he's hiding. Brown!
You wouldn't believe all this information that they told me in confidence that I could share with you.
Brown, what the hell is
this is the Simpsons episode when Ned Flanders goes to confession to killing Montgomery Burns, and it's Chief Wiggum in the confessional and says, "Well, this was a lot easier." It's like, yeah, well, I just got the confession straight from. When you're in a confessional in a church, though, it presents some legal issues to the confession. So just say there's some notable things there.
What attorney is using their clients' confidential communications
I didn't know
to
this
say
was
their client's a liar?
I didn't know this was an option, Nate. I guess I've been misunderstanding this all this time. I guess there's a whole bunch of things I'd like to tell you about.
Oh my God. This is insane.
Uh-huh.
This is insane. All right. My voice is going up too many octaves. This is wow. Just wow. This is a wow. Wow. Secret Squirrel for £5. Thank you for the £5 Secret Squirrel. If you guys are enjoying this back and forth and us laughing at the misfortune of poor
misfortunes of others, that's basically my channel. If you want to learn from the misfortunes of others, please subscribe to Uncivil Law. Basically, this is every video now.
And please, if you and I see some people are hitting us with long questions. I'm going to reserve those for super chats. If I'm trying to catch the questions on the site because I'm trying to get through the documents. So please, if you want me to answer something quickly, if not, I'm just going to pick and choose based on the chat. But and I'll try to get to as many questions as we can, and we'll look at some questions even after this. So this is why I was wondering if he was trying to get out of it. You should know better than this. Yes, Secret Squirrel, but this could also, this could be a hit on the license.
There could be an ethics issue in here for 1.6. There could be an ethics problem for our duty of confidence. Yeah, that could be an issue.
For selling, for giving away your clients. No, let me just be clear. For possibly, because I don't want to say he did it, allegedly, before I get it.
Allegedly.
So for allegedly saying your client is a liar because of the personal communications they gave you under the attorney-client privilege?
See, that's the kind of thing that raised question marks in my mind, Nate, as a lawyer. I'm like, I'm not 100% sure this is necessarily the greatest idea I've ever heard of.
Mm-hmm. Kimberly says, Snohomish. Oh, nice. Thanks. That's how it's pronounced. Thank you, Kimberly. Mother of, is that R-O-T-T-S?
Mother Rots, I guess.
Ah. All right. So let's continue on with this madness because this is straight madness. So it's on the 22nd, communications. So the defendant motion in which he purports to characterize his communications with his former client, Ms. Barnhart, of filing false statements. Mr. Brown also attached the relevant emails with Ms. Barnhart, nearly 200 pages.
Yes. Which is also, again, a potential ethics problem. Now he's trying to squeeze this into disclosing for 1.6 for defending himself, but he defended it. He provided basically everything in the open. He didn't attempt to attempt to minimalize or compartmentalize it, or a lot of things. So there might be a 1.6 violation there too.
And you can't just throw it out there.
He's trying to squeeze this into an exception, but he may have over-disclosed.
Oh yeah. Oh, do you think?
It could be. There's a potential problem there that might need to be examined.
Mr. Brown withheld those containing especially sensitive health information and purported to provide such emails in a separate supplemental declaration. So hold on, let me see this. Don't tell me.
He did do that.
Second supplemental declaration. So is this the stuff under seal?
Yeah, well, there was I can't remember the exact number, but it was less than 10. I think it was less than 5.
So this is the
emails that were withheld about about health specifically.
So hold on. This is even worse than I thought it was then.
It's pretty bad.
If Lorianne, all right, so understand this, people. If Lorianne told Brown about her specific health issues, right, under this relationship of him trying to represent her, right? Please, I'll represent you for free. She tells him, I have these mental health issues. Then he goes and uses it to discredit her later on. He has that is a monster ethical issue. That's not just a little ethical issue. That's monstrous. Because now he's revealing to the court, even though it's under seal, to help another client, attorney, that privileged information, no matter how you coach it, right? Her personal health information, if she discloses to Brown and he's now disclosing it to help another client without her express written consent to expose that.
Well, I don't know. This one I'm a little less confident on some of the other stuff because, it was under seal, so you can make a pretty credible attempt. It was compartmentalized and restricted, so I might give him more of a pass on that one, but the 200 other pages of stuff, even though it's somehow less sensitive because there's so much of it, that's more of a problem in my mind's eye. But how kept? I don't think that he could have actually revealed it, even though I understand what you're saying. It's not for public consumption. Yeah.
But the fact he's disclosed it to the court, and he's disclosed it to the court for the reason to help KJP. Those two things, I think, get you the ethical violation because that's something that you can't disclose, even under seal, right? Because the court's going to read it and say, okay, and use it for the determination. If I was a court, I would say, why would you be disclosing something that's clearly, I'm saying that's clearly attorney-client privilege, even if she was just a potential client. That clearly falls under attorney. So what exception can you even file it under seal? You're right. Public consumption, no. But he's filed it with the court. And now I'm assuming KJP and Saltz and them know because it's filed under seal.
Yeah.
Well, first, I want to ask you this. Maybe our disagreement is here. Do you think that information is attorney-client privilege? Because I'm saying it is.
Sure, of course. Why not? It's communicated in the scope of the representation. So sure, why not?
So if it's privileged, he now has filed it under seal.
Yep.
Public can't see it. But Katie Joy now, Saltz, and the court.
It's not necessarily clear that Katie Joy would necessarily have access to it, but Saltz would for sure.
And then it's in furtherance for Katie Joy's case. So Yeah, this is improper to release that information.
It raises question marks. Yeah, this raises. I wouldn't do this. I would not advise someone to do this. This is sketch, but some of the other stuff is more sketch somehow. But that's, maybe it's the total mass of it that makes it more sketch in my mind. Maybe it's the total number of it that somehow, even though it's less sensitive, there's so much more of it that like tips the calculus in my mind. But it's bad.
But before we even get to this next part, I'm just going to say it. I'm just not even going to pussyfoot around. Brown's. It's either he's playing 20-dimensional chess, or something's up here. Something is just wrong here, because this is not, a lawyer doesn't do this type of stuff. A lawyer, you can't, right? Your license is up. Your license could be up for grabs for doing shit like this. This is not something that you would just do just to do. You know what I mean?
Well, if it makes him feel any better, if it all winds up true, he's very unlikely to lose his license. He might only get suspended for a length of time. So there's that. Yay.
Yeah. And, oh my God, it's crazy. It seems Vidal Super Teresa Hart. It seems Brown maybe inadvertently illustrating how not to lawyer. I don't know. Again, he could be doing some backdoor something. I don't know, but this just doesn't make sense. Brown, you're not making any sense. Stop doing this. Let's continue. Because we got to get out of here.
If Lorianne Barnhart wanted to file an ethics complaint against Brown, she appears to have sufficient material to at least make a prima facie showing.
What do you mean? She said my lawyer's telling everybody my attorney-client privilege, right?
I think that's what I said, basically.
Yeah, she's telling me.
I might have phrased it more moderately, but yeah,
I told my lawyer
she appears to have sufficient information that could form a prima facie case. So yeah, there's that.
I told my lawyer I did it, and I'm crazy, and he went and told the court. What the hell is wrong with this guy? He's telling everybody.
Manifestation of what I said. Yes.
All our communications he just filed. He filed all our communications. What the hell does attorney-client privilege mean? Bruh, I don't know. This is crazy with Brown. Perhaps for a later video, it's there's a beautiful description of this duty of care, where a lawyer sought to represent both sides in the case in a state compensation insurance fraud. In State Compensation Insurance Fund v. Is that Drobot? Mm-hmm. Okay, I'll check it out. We went over a case earlier where a couple of lawyer. Thank you, John. I'm actually going to check that out. We actually went over a case where there was one for the what was it called? It was the West Virginia case with the now I keep forgetting it. With the coal mining thing. Yeah. So there's been cases like this. This is insane. Let's go over the motion to strike. Okay, motion to strike. Do I have it up on the screen? Because sometimes we get posted up on the screen. Here we go. Motion to strike. Defendants relied on hearsay evidence of the 3 unsigned declarations prepared by Mr. Brown, collectively the unsigned Barnhunt declarations. Now, just to be clear, me and Kurt agree 100%. The unsigned Barnhunt declarations have no evidentiary value. The statements that she made, though, can come in for impeachment. So we had a little disagreement about that earlier, but you're 100% right. They can use.
Well, it was in no small part to the fact that I was miscommunicating along the way. So yeah, we finally wound up on the same page. Yeah.
So the declarations that weren't signed, that Lorianne, that Brown wrote for Lorianne, they should be thrown out. And to support the instant motion, plaintiffs previously moved to strike this evidence in their opposition to motion to dismiss for sanctions under the rule. So I think their motion for sanctions is based on the unsigned Barnhart declaration, and if that's true, then you throw those out. I think it's clear. That's why you only get a paragraph for that, because you can't rely on them. Unsigned declarations is just they're worthless. Although potential conflict of interest and ethical issues plainly exist, disqualification isn't right. So I think this is the whole thing about it just not being, let me see, motion disqualify, ethical shorts. Let me see. He's talking about why it's not right. But I'm thinking it's the same thing we talked about earlier. The reason, and just so we can get through this a little faster, the reason why it's not ripe is because you still have the motion to dismiss. If the motion to dismiss is decided, then there will be no case to disqualify him for or qualify him for, so it doesn't make any sense. So that's why they're saying it's not right. First, you got to rule in the motion to dismiss. Then you can determine if Lorianne's even going to be a witness in the case. So there's a conflict, and the conflict is going to exist after the jurisdictional issue. That's exactly what Saltz is saying right now. Secret Squirrel for $5. Can we just take a moment and feel bad for Lori? All right, we're taking our moment. No matter what she's done in the past, she has now been mentioned in this lawsuit more than Toddy.
Everyone's been mentioning this lawsuit more than Toddy. Toddy has disappeared. I'm not sure Toddy knows she's still involved at this point.
Why would a lawyer who doesn't normally practice this type of law take on this case? And do you think he has viewed her private?
Well, I mean, I don't want to seem unduly arrogant here, but I don't practice this field of law, and I feel like I could have done better. So, I mean, come on. This is,
Yeah, like to be honest with you, I have done defamation cases, so let me just make it very clear. But in my first defamation case, right, this wasn't, you read up, you look, you do your due diligence, and you could see, like, here's other motion to dismisses. Here's the way they attack certain things. So I don't know. Everybody's first time, it doesn't go well. No. But I do think that
I think my first time would have gone better than this.
Yeah, this is not a first time problem. This is something else is going on here. We just don't know what's going on, but something else is going on here. Thanks again for the super chat, Kathy Ann. So let's continue. So we went over this, the motion. So he's the motion to qualify and all this other stuff. And why he's saying it's strategic. So we've already talked about that. I want to get through that. So I'm not going to mention all this. Depending on the court's ruling, just trying to figure out where we want to go. So Mr. Brown and Mr. Barnhart. So this is Mr. Barnhart. Mr. Brown and Miss Barnhart appear to have formed an attorney-client relationship. So this is where we get to the meat and potato. An attorney-client relationship exists when the conduct between an individual and an attorney is such that the individual subjectively believes such relationship exists. I think we're here.
Yep.
I think we're here. I don't even need to read any more of this, but I think we're here. The client's subjective belief, which is Lori Ann Barnhart, which she should subjectively believe, does not control on the issue unless it is reasonably formed. It is reasonably formed based on the attenuating circumstances, including the attorney's words and actions. A court must have the facts of what actually occurred between the two parties in order to determine the legal question of whether
thanks no small part to Mr. Brown himself, we have all that because of the many, many emails Mr. Brown himself dumped on the record. So we got that going for us. Yep.
An attorney-client relationship may be implied from the party's conduct, and it need not be memorialized in writing. Facts. Yep. Washington courts have held that even a short consultation, meeting, or conversation may create an attorney-client relationship. Again, if you don't tell them, or if you say something like what did he say earlier? I will stand with you, right? I will stand with you means I'm your attorney.
I'll stand by you.
Yeah. If I go into an attorney's office and tell him everything that happened to me, and he says, I'm going to stand with you, then guess what? That's my attorney. That's my attorney, baby. Here, Miss Barnhart testified. Again, we're talking about the declaration, that she had an attorney-client relationship with Mr. Brown. Brilliant, because it's about her subjective relief based on and the attenuating circumstances. I think that's fair. Defendants sought sanctions against plaintiff. This is where Brown fucked himself. Defendants sought sanctions against plaintiff's counsel for violating Rule of Professional Conduct 4.2, which when they spoke with Ms. Barnhart. Why? Because she was represented by Brown. Additionally, Mr. Brown advised the court on more than one occasion that he and Ms. Barnhart exchanged nearly 150 emails, 2 phone calls over the course of 18 days. While Mr. Brown only cites 2 emails from Ms. Barnhart in the instant motion to qualify the breadth and nature of the available correspondence as a whole appears to support Ms. Barnhart's reasonable belief that Mr. Brown represented her. For example, here we go with the examples. Ms. Barnhart repeatedly requested Mr. Brown's legal advice as early as December 31st, 2020, told Mr. Brown that she would not say nor do anything without telling him. First, Mr. Brown repeatedly offered Ms. Barnhart legal advice. Facts. Mm-hmm. Mr. Brown actively dissuaded Ms. Barnhart from contacting plaintiff's counsel. That doesn't move me too much. But Ms. Barnhart indicated that Mr. Brown on at least 4 occasions that she was inclined to contact plaintiff's counsel directly. However, Mr. Brown convinced her not to do so. I don't think that's too bad, But I think the other stuff is more than enough. Based on the preceding examples alone, Ms. Barnhart's subjective belief that the attorney-client relationship existed with Mr. Brown appears to be reasonably formed. I think I think
you want to go to legal aid for advice? Ha! I got your back, girl. I'm here for you, girl. Legal advice all day long.
I'm going to stand with you.
You don't need no stick in legal aid. Brown's
got caught with his hand in the cookie jar. Brown got caught with his hand in the cookie jar.
The thing that's bewildering to me, because his resume is solid. I mean, he was a clerk, I think twice, federal and court of appeals, I believe. Question mark. And he has the pedigree and experience. And I mean, every lawyer in the room is probably saying the exact same two words in their head over and over and over again. Conflict check. It's like, this is kind of basic. And if someone comes to you and asks for legal advice and you don't want to give them legal advice, or you don't want to be their attorney, you could say, well, I'll answer this, but I'm not your attorney. So here's some generic advice, but I'm not your attorney, so I'm not representing you. But okay. And Brown didn't seem to do those things, which is bewildering to me because, again, the pedigree seems. I'm confused, Nate. Also, if assuming he wrote the motion to dismiss, which might be assuming too much, because even that is somehow worse than all this. Somehow, at least in my own mind, the motion to dismiss was so bad. It's like, how does a competent attorney write a motion to dismiss that bad? I can only hope it was written by some associate or something, because it was truly a train wreck.
Oh yeah. Yeah. It was pretty bad. It was bad. I don't know. I don't want to go back to the motion. It brings me nightmares still. This is from Karen. Thank you, Karen, for the $10 super chat. This must be this must be totally drop dead diva. See, a pretty model that barely graduated from high school has clearly taken over Brown's body and tries to do his job. Crazy filing ensued. That's true. This may be a drop dead diva.
She was a high school student. He was a practicing lawyer. Then one night.
Hold on. Let's look at you know what? Let's I got to do this. I got to see it. Here's Michael P. Brown. Here he is right here. Here's the law firm. He's a good-looking guy too.
He's a good-looking guy. Yeah.
Represents both plaintiff and defendants, complex insurance recovery, class action, education. JD from University of California, UC Davis, right? Oh, not bad.
Yeah. And order of the coif, which means it was with honors.
Yeah.
So he had honors of some variety. So he was a top law student.
Yeah. 95 too. So he's been doing this for a while.
Yeah.
Let's see.
He went to clerk for a United States District Judge and then Ninth Circuit Court of Appeals. My confusion grows.
He's got this, some nice little cases he's got done here. So Brown doesn't seem like he's got it's just a couple of cases. Personal. One of the most rewarding things about being an attorney is the satisfaction I get providing practical help to people who are in difficult situations. I spent time with my young son. So Brown seems solid. I would hire this guy based off this.
I'd hire this guy based on this resume. I mean, yeah. Yeah. So I don't know what that means about anything, but yeah.
Brown, this case is not helping Brown's legal career, though. I'm telling you. 2014, the U.S. Supreme Court ruled. So he's even got something. Michael is seeking class status. So Michael, he's got something going on here. If I'm Michael, maybe he is trying to get out this case because I don't see why. I don't know. The resume doesn't match what I'm seeing here. It just doesn't. It just doesn't. I'm sorry, Michael Brown, but this is not helping. This is definitely not helping. All right.
We've apparently not heard of conflicts checks and
conflicts checks. You must be crazy. Get out of here with your conflicts checks. What are you talking? Hey man, we're shooting from the hip here, brother. We don't care about no conflicts checks. That seems to
be for sure. Yeah.
Thanks for new member Kim. New members. Hey, blonde Asian. What's going on? Thanks for becoming a new member, Kimberly. Welcome to the madness. Boom. So let's continue reading on with the madness. The madness. So Miss Barnard, so we read all this. We read all this. So we all agree. I think everybody in the chat, everybody in the world agrees that at one point, if Brown, at worst, Brown, there was an attorney-client relationship with Brown, between Brown and Lorianne. At best, and I'm talking about the best case scenario for Brown is that she was a prospective client, right?
Yeah,
that's the best I think Brown can hope for.
Yeah.
At the very least, guess see what comes up next. At the very least, Mr. Brown and Ms. Barnhart formed a prospective client relationship. So this is exactly what we were talking about before, about the case in West Virginia. The prospective client and how you owe the duty to this prospective client. So that's what we got here. Let's read what Brown says. Even assuming Mr. Brown and Ms. Barnhart didn't have the attorney-client relationship, Ms. Barnhart appears to be, at the very least, a prospective client to whom Mr. Brown owed certain duties. And they go to the rules of professional conduct, 8.118, that establishes the duties owed to prospective clients. The rule provides a relevant part. A person who consults with a lawyer about the possibility of forming he definitely did this of forming a client lawyer relationship with respect to a matter is a prospective client. Boom. Do we have this first one? Check, right? Check.
Yep.
So B, even when no client lawyer relationship ensues, a lawyer who has learned information from the prospective client shall not use or reveal that information. I think we got that violated, unfortunately, because he did learn information from the prospective client, right? Mm-hmm. He did. He showed us. He showed us the 200 plus emails.
Yeah,
right.
He made sure to make sure that we knew that he received information from his client. He was more than eager. More than eager to share all the confidential things to show that, So we got that for us, yeah.
All right, but then with this exception, Rule 1.9, that permit with respect to information of a former client who provide. So we'll look. I'm hoping he'll go through that, and then C, a lawyer subject to paragraph B, which Brown is, right, because we accepted that. B shall not represent a client with interests materially adverse to those of a prospective client in the same or substantial related matter if the lawyer has received information from the prospective client that could be significantly harmful to that person in the matter. Brown's in trouble.
Let me go with it's not significantly harmful. I mean, I don't really believe it, but I'm just trying to figure out something that might work.
If I'm reading this right, Brown's got a problem. This is a problem. This is a problem.
Yeah.
Comment. So now the comments to Rule 118. Whether communications, including written or electronic communications, constitute consultation depending on the circumstances. For example, a consultation is likely to have occurred if a lawyer, either in person or through the lawyer's communications in any medium, specifically requests or invites submission of information about potential representation. We got that in spades, right? We got that in spades. Without clear and reasonable, understandable warnings and cautionary statements that limit the lawyer's obligations. And a person provides information in their response. In contrast, consultation does not occur if a person provides information to a lawyer in response to a communication that merely describes the lawyer's education, experience, areas of practice, contact information, or provides legal information of a general interest. So Brown is screwed. Brown is screwed because he's providing straight up legal advice, right? Give me this information. And we know he has information that's crazy sensitive. He's got all her medical stuff, right? That he learned through this relationship, right? As a potential client, even if we're saying she's a potential client, but now he's got all that they had to put under seal because it was so personal. Brown's in trouble.
Yeah.
Brown's in trouble.
There's problems.
There's problems. If I'm Brown, I'm like, yo, we got to talk to the ethics board. It may be a problem.
Problems might involve tropical islands. I'm just saying, without extradition.
This is crazy. This is insane.
Way down in Kokomo, where they can't get to me
John
because I'm
John
outside the territory.
John Bryan for $10. I'm pretty sure the first thing drilled into every young attorney when asked a legal question socially is that I want to be clear. I'm not your attorney, and this is not legal advice. That's what we say all the time, right? This is what we say at the preamble. This is not, and just to be clear,
Emily Baker has a whole intro with it, with with her intro. She's got that covered too. Yeah.
And just so everybody knows, so I don't want to get caught up with I'm gonna call this the Brown. I don't want to get caught up at the Brown. This is not legal advice. Anything you hear is a straight commentary, right?
Oh no, I like this idea very much. We can name this entire thing after him. And we can say, all right, don't pull a Brown, man.
Don't pull a Michael Brown. Don't pull a Michael Brown. So I don't represent any of you people. Remember, and this is not legal advice. This is not a Michael Brown. This is not a Michael Brown.
Also, you're covered by the last sentence of the comment because they wouldn't be legal advice, wouldn't be attorney-client because they'd be providing you information in response to general legal information, general interest.
So. Teresa says, I'm hoping that either Nate, Uncivil, or Emily come up with a merch that says, I'm not your lawyer, nor is this legal advice. No, my shirt is going to say, I'm not your lawyer, but I'll hear what you got to say. That's the Brown. That's the Brown. I'm not your lawyer, but tell me all your secrets anyway. No, Brown. So I can tell it to whoever I want to tell it to. Brown. I don't know how Brown I caught it.
Apparently, the way to get someone to tell them your secrets is just to tell them that you're the FBI. Because I learned that from my FBI Capitol Riots here. It's apparently the way to get them to tell you secrets is I'm from the FBI. Great. Let me tell you all the things I did. Let me show you the social messages. Let me show you my Facebook page. Would you like to learn more about my day? By the way, I know I'm not supposed to have firearms in DC, but I do anyway. That literally happened. Oh my God. And please search my trailer and stuff. It's so apparently the way to get secrets is just say I'm from the FBI. So yeah.
Well, then not Brown. Brown just say, hey, I'll represent you for free.
Yeah.
That's what he said. I'll represent you for free. Tell me everything. All right. Blonde Asian. Oh my God. I wanted to say thank you for the info.
Yeah.
On your George Floyd stream yesterday. Oh, thank you. It's
I need to do one myself today because I need to work through that opinion that the Court of Appeals cited on the George Floyd thing on the third-degree murder and see if I can explain it to myself.
Nick did a very good job explaining.
Yeah, I saw his, and I'm like, I need to do my own video where I go through it and see if I can explain it to myself and see if it makes any sense.
Because you know what it is? They essentially just saying it's reckless murder. That's kind
of the end conclusion. I want to see how they got there, particularly in light of precedent, because it seems not supported.
No, it's not. I agree with you, but hey, the court's always right because they do whatever they say. So whatever. But I agree with you. I think it's BS. I don't think third degree is appropriate. But I don't practice in Minnesota. Just be clear. I don't practice in Minnesota. This is not legal advice. If they get him on third degree, so be it. I think the guy should definitely go to jail. But
I mean, I assume the prosecutor has contemplated the non-zero probability that they could get a conviction on third-degree murder. It could get appealed, heard by the state Supreme Court, and overturned, and then double jeopardy is attached, and he's free. So there's all that. That's a possible thing that could occur in the future. So
no, but they wouldn't. They wouldn't.
I'm not sure necessarily.
It all depends if he was acquitted on the other charges.
Yeah,
and only convicted.
Yes.
Only
hypothetical. Yes,
because if he was convicted on the other charges, then they could send it back down for a retrial, for instance. So
this is the hypothetical. Yeah, he's only convicted of the third-degree murder. It gets appealed. The Court of Appeals will, of course, uphold it because they just told us they would. Mm-hmm. And so then the state Supreme Court gets involved, overturns it. He goes free. That should make everyone super happy. So I wonder as you're a former prosecutor, so you tell me. Mm-hmm. I mean, with this kind of potential legal uncertainty as a possible future, would you press the third-degree murder even if you could? Would you? Press that?
I would actually pre-pressing. I think the second-degree murder I would press. Third-degree murder. The reason why you want third degree, and before we move off this, the reason why you want third degree is you more bites at the apple. You got the manslaughter for 10 years, third degree for 25, and second degree for 40. And so a lot of times juries like to give you that we don't like second degree, we don't like this, but we like this, and that's kind of the
That's
just
kind
in
of,
case we
but
the in
that's
between.
yeah, I understand that. Like, I understand the idea. It's like we want to give the jury options in case they don't go for the top count.
Yeah.
But you do have to worry about the possibility that they'll come up with a compromise verdict. So some people will think, yeah, maybe some people think it's manslaughter. Some people say second degree murder. It's like, let's settle on third degree.
Yeah, you're right.
So the jury comes back on third degree. And so you have to worry about the probability they'll come back with only a third degree murder conviction and all the nasty things I said. So it's like, as the prosecutor, do you really want to give the jury that option? Because there's a combination of things the jury could come back with and a combination of things the state Supreme Court could come back with that's going to cause you to have a bad day.
Nah,
so it's like, do you really want to press that option? Maybe you should ask Emily D. Baker. She's a former prosecutor.
Yeah, she is too.
She's hanging out in the chat. Emily, what do you think? Emily, do you think this is a good idea? Do you think the prosecutor should go forward with this?
Let's move back from Joe, because I do think the prosecutor should move forward with this. But let's finish this because we got an hour and a half in. If we go into George Floyd, we're going to be here for another hour and a half.
All right, fair enough.
My bad. But Emily definitely can speak about it. But I just want to get people out of here because I know people came here specifically for this. So I don't want to go into the George Floyd madness. No, that's fine. It's an interesting legal issue. Here, Mr. Brown and Ms. Barnhart exchanged nearly 150 emails over the course of 18 days. Okay, so he's hammering that. And again, this is repetition. For you guys who want to be lawyers out there, this is a master class on writing these things in a very, very in a way that's very persuasive. You see the repetition. You see he's hitting those same words all the time. His former client, 18 days, 150 emails, making sure it's, by repetition, the judge and whoever's reading it is always continuously hearing it. So even when you guys leave, if I say how many emails were between Brown and Lorianne, you're going to say 150, right? Because he's been telling us, and we've been reading it every couple of lines. So this is textbook persuasive writing. Email to Ms. Barnhart contained any clear and reasonable, understandable warning or cautionary statement that's limited his obligations to Ms. Barnhart. Instead, Mr. Brown made numerous requests and repeated invited Ms. Barnhart to submit information about herself and the matter at hand. He's burned. Ms. Barnhart disclosed substantive and confidential information to Mr. Brown that could be significantly harmful to her. Specifically, the thing about her mental health. I think that's what gets you this, right? You can't get past the mental health thing. If she disclosed that to Brown, it's over, right?
Could be.
It's over. I don't think. Let me see what the 69 is. 69, second supplemental declaration of Brown. Yeah, I think Brown burnt himself. I think he just burnt himself with that. Mr. Brown, therefore, may be barred from using Miss Barnhart's confidences against her and is barred from representing defendants who have adverse interests in the same manner. Agreed. The record reflects a significant conflict of interest. While the plaintiffs have not yet moved to disqualify Mr. Brown and his law firm due to disqualification issue not being ripe, agreed, it is apparent that the conflict of interest exists, such that defendant's motion to qualify should be denied. Of course it should be. Mr. Brown asserts that his communications with Barnhart were for two purposes. One, to explain the abusiveness of the Fulmer Declaration, and two, to confirm defendant's statements that they did not know Ms. Barnhart resided in Washington until that fact was disclosed in the lawsuit. However, Ms. Barnhart's testimony on January 13th states, among other things, that the Fulmer Declaration was accurate, with the exception of where Ms. Barnhart allegedly worked, and that defendant Paulson did, in fact, have reason to know that Ms. Barnhart resided in Washington by at least April 2020, if not earlier. And three, defendant Paulson misrepresented the nature and scope of defendant's Washington context in her declaration filed in support of the motion to dismiss. Notably, Ms. Barnhart's testimony centers on the same issues Mr. Brown admits were the subject of his former representation, and her testimony is not favorable to Mr. Brown or his current clients. In fact, Mr. Brown alleges that Ms. Barnhart's testimony and the signed declaration changed the first story she told him by 180 degrees. So it seems like Saltz is saying exactly what we've been saying all the time. He has to, and this is where I think the conflict really exposes itself, because for Brown to argue the jurisdiction, right? Since now Lorianne's involved in this. He has to throw Lorianne under the bus. But you can't throw Lorianne under the bus based on what she's told you because of the either proposed representation or the actual representation, right? Is that what we're getting here?
Yep.
So at the end of the day, that Mr. Brown contends that Ms. Barnhart's testimony is now in opposite to the position is enough to establish adversity. I think it's true. The fact that Brown is saying her story has changed 180 degrees and it's adverse, that's true. I don't see how Brown gets over this. The crux of the adversary inquiry centers on a lawyer's duty of loyalty, like I mentioned earlier. Parties are not allowed to switch sides. Lawyers are not. The underlying question is whether a lawyer, and that's the issue you had because you said she's not a party, which is true. She is a witness. Whether a lawyer was so involved in the matter that the subsequent representation can be justly regarded as a changing of sides is in this matter in question. Not only is Ms. Barnhart's testimony unfavorable to the defendant and Mr. Brown, but also in nearly every one of the defendant's filings since January 13th, 2021, defendants and Mr. Brown have attempted to use Ms. Barnhart's communications with Mr. Brown to discredit her. This is where I think you get the big ethics issue because they are using specifically Ms. Barnhart's communications with her attorney or her alleged attorney, right, at the time, which she just subjectively believed was her attorney to discredit her. Brown is not allowed to do that. Does that make sense, Kurt?
Yep.
So if this is true, Brown is screwed.
Well, again, I don't know about the materialization in the case because I think the issue in the case can be rectified with fairly minimal problems. The ethics issues are more problematic from my mind.
Yeah.
Because I mean, the way to solve this within the confines of the case is assuming Lorianne Barnhart testifies and he can't represent Katie Joy and Lorianne. So the way to solve that or question, he can't represent Lorianne. Apologies. Let's try this again. He can't represent Katie Joy and question Lorianne. So the way to solve that problem would be to have someone completely independent to do that portion of the case, which would solve the other problem for the purposes of this case.
But then what about all the information that Brown found, that Brown knows about Lorianne that he's already exposed in the case? Is that just a gimme? Is that just a gimme?
That's a good point because that information is confidential information has now been exposed. So I suppose the only way to cure that would be you'd have to get someone as attorney doesn't have any particular familiarity with the case at all, which shouldn't be that hard because I know that this case is notable to a lot of people on the internet and has a lot of interest, but in the grand wide world, it's just another case. So you could find an attorney completely unaffiliated and be like, yeah, you can't look at certain things.
But then do you strike problems? Do you strike everything that essentially? Yeah. Why isn't Saltz asking for a motion to strike everything that Lorianne said? And the reason being, it's because of attorney-client privilege, right? The attorney-client privilege between Lorianne. Well, I think part of it, if Lorianne gave the stuff that Lorianne gave to Saltz, it's third party, right? Because the privilege is Lorianne's. But now all this other stuff that Lorianne didn't expose to Brown, right? Mm-hmm. But Brown exposed. That I think should be tossed, right?
Because I think a motion to strike could be upcoming. I just assume not have any motions at all because I want to actually decide the jurisdiction issue. Anyone remember that? But
jurisdiction?
Yeah, the motion to strike could be upcoming. But yeah, so you might be able to solve the conflict problem by getting an attorney who has no knowledge of the case and isn't exposed to this information to be able to develop in that. And so that might solve the conflict. The ethics issues for Brown are, of course, a wholly separate problem.
Oh, yeah.
But they might be,
Well, from this, the defendants and Mr. Brown have attempted to use Ms. Barnhart's communications with Mr. Brown to discredit her, accusing her of submitting false statements under penalty of perjury and/or alleged that she doesn't have the capacity to execute the signed Barnhart Declaration. Again, this is horrible. Moreover, if and when the case proceeds, Mr. Brown may need to cross-examine. So you're speaking about that, to cross-examine. So the issues about the attorney-client relationship, the sole purpose is trying to create doubt about her truthfulness. Further, if Barnhart testifies at trial on any facts not favorable to defendant to represent Ms. Paulson to the best of his ability, Brown must attempt to discredit that testimony. And again, so that's exactly what we're saying. Brown can't really have anything to do with Lorianne based on the evidence that we have now. And that would be the conflict. So I don't think he has to Saltz has to convince any of us. Accusing a former client of either incompetence or a crime to benefit another client in the same manner could not be a clearer conflict of interest.
Yeah.
You could have started off this damn thing with this, right? We read through 17 pages of this crap. This is the line. He cannot accuse a former client or even a former potential client of incompetence, especially based on the information that client provided to him under the privilege. You can't do it. And that seems to be what Brown has done. Therefore, Mr. Brown and his firm cannot exercise the duty of loyalty to both Ms. Paulson and Ms. Barnhart. So now it seems like he's saying Brown should be disqualified, but then at the end says, for the foregoing reason, the place will respectfully request that the court deny the motion to qualify. So deny the motion to qualify. Brown obviously should, has an issue here, and the bombs explode. So we're at the end. What about jurisdiction? Jurisdiction seems to be something that...
What about Toddy?
I don't know.
Do you think we'll get a jurisdiction decision ever?
I want to see. I don't know, because I think right now jurisdiction runs everything. If there's no jurisdiction, all of this, right, was for absolutely nothing. Think about it. If the court says you don't have jurisdiction, only thing that hurts is Brown, right? Because this is Brown's in Washington, so now he may have ethics issues in Washington, but Saltz gets to walk away. Everybody gets to walk away, right? The only person this is hurting is Brown. Who else is this hurting?
Well, I guess it's hurting Toddy in so much as she's paying a whole bunch of legal fees that are also going to disappear in the air to the extent that she cares. I mean, she has money, but I would imagine this amount of money would be notable even to her. But what do I know?
Yeah, but think about, I'm just saying, even without the money issue, because I'm thinking Toddy has the money to deal with it.
Yeah.
Whatever she wants. So let's say she has the money. The thing is, I'm thinking just professionally, this just hurt, because if this is true, everything they're saying is true, Brown has an ethics issue, even if the case goes away, right? Because ethics issues don't. Oh yeah, no,
ethics issues are not going to disappear. Yeah, they're not going to disappear.
Yeah. So I don't think. I think Brown has an issue, and revealing clients' personal information and doing all it's and revealing communications and using those communications in an action for another. It's bad, man. This is bad. I don't see how I don't see what could Brown's strategy be? I gotta ask you, bro. What is Brown's strategy? What is Brown? Let's just. Is Emily still here in the chat? Because you said Emily was here in the chat. I think she disappeared on us because she never answered my question. What the hell? What the hell could Brown's strategy be here? I don't see what it could be. Tell me, what is Brown's strategy?
Well, the strategy in sort of following every motion under the sun possible is presumably to frustrate Toddy and drag things out, and there's also this idea that Swanson, and this is of course pure speculation, I have no information to support
speculation
this.
Time.
Yeah, pure speculation time, that Swanson might be providing the legal fees to Katie in the hope that through their lawsuit, information will come to light that will assist him in his lawsuit against Toddy dealing with the business partnership. So there's that speculation so maybe it's partly to frustrate, maybe it's to drag it out, maybe it's to distract Toddy's attention, maybe it's to try to gain information through this process for another process. So in terms of why all the filings and why the aggression, that could be the motivation. Why the motion for dismissal was written so poorly, I can't say. Why Brown is, I don't really like the uber aggression, so it doesn't really work for me. And why he did things the way he did with respect to Lorianne He never really ran a conflict. He never really advised her as to her status one way or another.
I will stand with you.
Well, yeah. I mean, he didn't. He never said I'm representing you or I'm not representing you. He never was explicit either way, but he certainly made a lot of statements that towards the representing the not.
No,
And then
hold
why
on.
he disclosed so much stuff on the open record, and why he, yeah, I don't. He's going to try to squeeze this all into the rule allowing you to defend yourself, and it's going to be tough.
But Kurt, the problem here is that even if he's saying that she wasn't my client, because that's essentially he's saying that she was never my client.
Yeah.
But even that, that still doesn't work, because potential clients get essentially the same type of protection.
Yeah.
So he loses and the fact that he said, I will do it for free. I will file the paperwork. I will, stand with you. Even if the court says, well, he was not her client, even because, again, it's about her subjective belief, the potential client, then he's screwed either way. Because I think without her saying anything, she was definitely a potential client. I don't think there's any argument, unless somebody in the chat can maybe make an argument, that Lorianne wasn't a potential client of Brown, right? I think that's clear. But now, how is Brown going to, I don't know how Brown's going to respond to this.
Yeah.
Because I would be, honestly, I'd be afraid of an ethics violation if I was Brown. You're telling me with all this, you wouldn't be afraid of, have any fear of an ethics violation?
No, I didn't say that.
Would you?
Yeah.
Yeah, I would be very frightful. But well, first I want to make sure I clear two things up. Number one, I'm not saying that Brown committed any ethics violation.
I'm definitely not saying that either. Yeah, no, I'm definitely not saying that. There's just questions.
What we are saying is that based on what we've seen, it would be very unlikely, it seems to be very likely that there could be some ethics violations that should be looked into, because, based on this record, it just, there's a lot of smoke here, but that doesn't mean there's fire, but there's a hell of a lot of smoke. Communication between clients and potential clients. And it just, I think Brown, I'm not sure what Brown's motivations are here, but this, this just doesn't.
The thing that's probably going to tilt this one way or another, to be quite honest, is the degree to which this is repeated behavior in other cases. That probably is a major factor here. If this is like a one-off somehow, then I could see this not really going anywhere in terms of an ethics violation. But if it turns out that this is more of a pattern of conduct, then yeah, that could be a problem. So that depends. I guess it depends what any potential investigation would show as to how this relates to other representations. So yeah, that's kind of where I think that would break down one way or another.
It says, I think this question is more for you. It says, why would Swanson be paying for KJ's lawyer when Halo, hence Swanson, is a party in the other case?
Yeah. So in the other case with Swanson versus Toddy, it's about the business partnership between them and related to Halo. And so they're suing each other over, I can't even remember what, because it's been so long. But the idea would be that Swanson would be paying for Katie's legal fees, or this is the speculation, potential speculation. This potential speculation is that Swanson would be paying for Katie's legal fees because he would be imagining that through that discovery process, some information would come to light that would somehow assist him, that he feels like he'll get some sort of edge, or he'll be able to learn things that will assist him in some way. Or the other idea would be that's just a distraction to distract Toddy's energy and to take focus off the current matter, or to buy himself time. So there might be some motivations for him to front these costs for strategic reasons on his own end. So could be, I guess.
Well, we're going to take this last 5 minutes for questions. So if you guys have any questions in the chat, obviously super chats get priorities, but any questions in the chat, we'll try to answer them and go through them real quick. We're going to start now because I'm not going to be scrolling. We're going to be able to scroll back because there were a lot of stuff coming in. But at the end of the day, do you think? Well, I think both these motions are going to be like destroyed. I think
everything's just a distraction. I remember the last time I cared about something in this case.
Is a quick question. Isn't it more likely that Katie's home own? Is it more likely
That seems
Isn't
unlikely
more likely
because
that Katie's homeowner insurance?
usually it only protects for negligent acts, and defamation is usually thought of as intentional acts. So it's unlikely the homeowner's insurance would pick this up.
Question is, what are the ramifications for Groupon lawyer Brown? The possible ramifications is that everything from an investigation to a warning, and he can actually have there could be some ethics violations where where you look him up and you see that he's had this ethics violation. I think the biggest issue for Brown is that the fact that it's the one sacrosanct rule for being a lawyer is keeping your mouth shut about what your client tells you, or even what a proposed client tells you.
Right? And also, don't screw with the client's money. Those are two good ones.
Don't screw with the client. Well, make it entangled. Don't screw with the client's money, and don't tell anybody what the client has said. That's it.
It's pretty. Those are pretty good rules. Yeah.
Brown has told us everything his potential client has said. Not only that much, but even the most personal things, right? The stuff that that had to be put under seal. It was so personal. That is one of the biggest no's in the legal profession, right? Just imagine you going to your lawyer and you're supposed to be able to tell your lawyer if you did it or not, right? Hey, I killed this guy, and your lawyer's supposed to go in there and still fight for you to get you off, And this, right now, Brown's saying, yeah, my client told he did it. So that's I think that's
anyone wake me up when there's a decision about jurisdiction. That's what I'm thinking about saying. Just wake me up when there's a jurisdiction decision, so I can go analyze that and actually analyze some law I'm interested in.
Nate, the lawyer, with all these distractions, would the case be any further along than it is now? Yes,
probably.
We probably have a ruling on a motion to dismiss it to probably be over. That's probably where we would be at. Question: would an insurance lawyer claim to be an expert in defamation, legal writing, present this kind of dumpster fire? Was KJ duped?
I don't
listen. I can't. I'm saying this. I believe that Kurt, who is you do copyright. You're a copyright lawyer, right? That's your specialty.
Patent.
Kurt's patent specialty. Mine is criminal, right? When you're writing these type of things, you have a duty of competence. And I think any competent attorney would have written a motion to dismiss, attacking the underlying claims. Now, there's strategy, there's things. So I can't blame Brown, but I don't know what the overall plan is. I don't know what the overall strategy is. This is legal commentary. So I'm telling you, I just don't know what Brown is doing. I don't know why he's doing it. I don't know why he's making all these mistakes. Maybe this is something that they can do there in Washington. Who knows? But at the end of the day, would I be happy with the representation for Brown paying $4.50 an hour? No, I would not. I would not be happy. And if I'm paying for this disqualified counsel and all this stuff too, I would not be happy with that either, because it just. I would be looking for for some reduction in hours here. Like, this is supposed to let's just finish the motion to dismiss. So, question: will this ever be over? Who knows? Question: if town wins jurisdiction, can they ask for attorney's fees for all the extra filings? I don't believe so, but hey, you may be able to shoot at something here. Two more questions. One. Kurt, you're falling asleep. Oh, reports it's 10 o'clock, but maybe you are. And question: could this be a strategy for the opposing clients? Get fed up, they'll drop the case. Possibly, but I think Saltz is in forever, and I think Brown. If they're hoping Saltz is going to drop out of this case, I don't think you're going to get there. What do you think, Kurt?
Nope.
Yeah. If that's the strategy, then I think it's a losing strategy. I think so. I don't think it's dropping this case. So, everyone, thank you for this dramatic 2 hour and 15-minute dramatic read through this. I think we've all come to the same conclusions. Either Brown's is a evil genius, and we are just not worthy for his superior legal knowledge. I am not worthy, or
we'll learn something. Yeah.
Or this is probably one of the worst cases and issues that I've ever seen, and some of the worst filings and legal reasoning that I've been witness to. I'm glad to see the train wreck, but I just don't understand it, but it may not be Brown. Brown may be a genius. It could just be my stupidity that I'm just not able to
with
rationalize
with
this
respect
madness.
to Brown, though, I've seen some shady shit in some bar journals and disciplinary notices and cases. So I've seen some shady shit, man. So yeah.
Well, I've seen it too, but I'm just saying. I just want to make it very clear.
Yeah.
This Brown could pull up. You know, instead of like this a reverse card, he pulls a draw 4. You know, Uno draw 4 card. If that's the case, then he's got it. But I just don't see it, and maybe it may be my lack of understanding of the jurisdiction in Washington, rather than Brown being anyway incompetent. But if you're asking me as a legal commentator, well, my opinion about Brown is, I think Brown has torpedoed this horribly bad, but we will see. Last words to Kurt.
I'm good.
And with that, we are out of here. Thank you for watching. And next filing, Emily first. Probably either Emily or Kurt first, because I'm going to let them do their thing, because I like to watch their dramatic reads. Then I'll come on afterwards. So we'll probably be doing this again the next time this comes out. Motion to dismiss. Hopefully the judge will find something. Thank you for watching us for the 577. And please don't forget, like, share, subscribe, do all that great YouTube stuff. My name is Nathan Lloyd. This is Kurt, Uncivil Law. We are out of here.